On behalf of the more than 20 lawyers in the labor and employment practice of Saul Ewing, Arnstein, and Lehr, welcome to the more than 450 of you who have registered today to attend our annual executive series in labor and employment law. Today's topics will range from navigating COVID-19 issues to concerted activities to issues and solutions that employers need to know right now for today's problems and issues. My name is Gary Eidelman, and I'm delighted to be joined by my partner, Dita Kalo. Together, we co-chair the firm's labor and employment practice and will serve as your moderators for today's program.
So I have a few housekeeping items, and of course, we're going to go through a few things before we get started. Q&A. So because this is a webinar format, you can ask questions through the Q&A function below. The chat function does not work. I know we've all been sitting through these sort of webinar formats on Zoom, and you may be used to the chat function, but please, if you have questions, use the Q&A function below. We are going to try to answer those questions as they come in. As you can imagine, we have a lot of material to go through today. So we are also going to have a question and answer session at the end of our program today. We're going to stay after from 12 to 12:30 as well. And in addition, if you would like a 10-minute one-on-one session with any of our attorneys, we will, you can use the Q&A function below to request that. I am going to be monitoring the Q&A, and we can schedule you for that one-on-one at a date following the program. Accreditation. There's a lot going on today by way of accreditation. Today's program has been approved for continuing legal education, credit in Delaware, Florida, Illinois, Minnesota, New Jersey, New York, Pennsylvania, and Tennessee. We are also have an application pending in Virginia. We have also been approved for SHRM credits for our HR people on the call and HRCI recertification credits. Now, in order to verify your participation and receive your credits, you'll need to complete a brief continuing education verification survey. And during the presentation, there are going to be 2 random numeric codes that we are going to provide. The verification survey link was included in your reminder email that Chris sent out yesterday, and it will also open automatically in your browser at the conclusion of this webinar, following our Q&A panel again at 12:30. So there's going to be 2 different times today that it's going to pop up automatically. And you need to complete the survey within the next 5 days in order to get your credit. We're going to follow up today's program with a thank you email, and that will include access to the presentation materials, the continuing education verification survey, and any other relevant materials that we'd like you to have will also be coming to you. And of course, we wouldn't be lawyers if we didn't give you a legal disclaimer. The provision and receipt of the information in this presentation, 1, is not legal advice, and 2, does not create a lawyer-client relationship and should not be acted on by you without seeking your own professional counsel who have been informed of the specific facts of your case. So back to Karen.
Thanks, Dina. So folks, let me give you your roadmap for today. Before we begin with our first presentation, I want to briefly introduce today's panelists and topics. First up is Rob Dustin from our DC office, along with Lisa Koblin from our Philadelphia office, who are going to discuss COVID-19 vaccines and the workplace. They'll be followed by Steve Kerbaugh from our Minneapolis office, along with Lisa Koblin pulling double duty, which she does a lot around here, who will discuss remote work policies and considerations during and after COVID-19. They will be followed up by Antoinette Theodosakis from our West Palm Beach office, joined by Alex Rich from our Chicago office to discuss long COVID as a disability under the ADA. Angela Middleton from our Philadelphia office, joined by Steve Kerbaugh, somebody else doing double duty today, will discuss the fundamentals of effective diversity, equity, and inclusion initiatives. And certainly, last but not least, Dan Alchek from here in Baltimore, and Garrett Buttry from our DC office will discuss the NLRB re-energized and focused on non-union employees. And with that, let's begin. I'm going to turn over the controls to Rob Dustin and Lisa Coblin. Let's get started.
Thank you very much, Gary. I am very pleased to be here today with my colleague, Lisa Coblin. Lisa and I presented the firm's first webinar on COVID-19 in early March 2020, the day that it was declared a pandemic, and it has not stopped since then. How quickly things have changed. Next slide, please. Here's what we're going to try to do today. Touch base on mandate issues up top overall, talk extensively about the executive order on government contractors, touch on what we think is going to be in the new OSHA rule, which could be sooner than any of us really anticipate, and then get into vaccine mandates, the pros and not so much the pros and cons, the factors you need to consider in your programs, whether you're trying to comply with government orders or do it on your own, implementation and practical issues, and then that all a very popular issue of disability and particularly religious exemptions. Next slide, please. So we're often asked, how do we prioritize all the stuff that's thrown at you? And this slide is our little checklist on really how to, at the 30,000-foot level, prioritize what it is that you need to follow. The law and the science always start with your executive orders, your local orders, the federal laws, they come first. And following the science, it's always back to the CDC. The CDC guidance, even if it seems outdated, is still considered best practices. It's followed, and then whatever your local health officials say, if they are supplementing that. But in a time when virtually all public health officials have removed most or many of their requirements, the CDC guidance is still your best practices. And in some cases, that's been incorporated into EEOC guidance, so it actually becomes law. And we're going to be giving some examples of that. Then the EEOC guidance in particular, and when I say by guidance, it's the technical assistance that just got updated the other day, as well as older EEOC guidance on the same issues under the ADA and Title VII. And just because it's such a common question, it continues to be the case that your workers' comp liability issues on all of these issues are relatively low risk. It is very, very hard as a practical matter to prove that a workplace claim came or COVID-19 was contracted in the workplace. And even if it is, in every state that we have heard about, it would be covered exclusively by workers' compensation and not by state tort claims. Next slide, please. Big picture, it's amazing to think that 6 months ago, we were still cautioning against any kind of vaccine mandates or to take your time because all the vaccines were still under emergency use authorization. And of course, 5 months ago, those of us who were vaccinated were taking off our masks because we were told, however briefly, we could do that and how quickly that changed. The discussion of mandates and the whole idea of vaccine mandates had evolved very quickly over the summer. First, it was the colleges and universities who were moving from mandates for students and in many cases employees in advance of the fall semester. Then federal agencies started imposing individual mandates. And of course, suddenly, or it seemed very quickly, the Biden administration came down with its executive orders for both federal government contractors and announced that there would be one on a new OSHA rule. So very quickly, many employers have pivoted to, if they weren't thinking about mandates before, they are now, either in anticipation of these regulations or for their own safety protocols as part of return to office or reopening of offices, or for those facilities that have already been opened because of safety concerns. And the focus has shifted to the practical issues. And we are painfully aware from many of our clients in this era of the Great Resignation and staff shortages, or the Great Reshuffling, depending on your metaphor, about the trade-off. If I institute mandates, can I afford to lose those people? If I'm complying with mandates, how am I going to deal with the people who just refuse to comply? Next slide. So when we talk about mandates, we found it helpful to think about two different kinds of mandates. The first is what I truly we call a hard or a CAPM mandate, where full vaccination is a condition of employment absent a religious or medical exemption. If you don't get this, if you are not vaccinated and you don't have an exemption, you will be fired. A softer mandate is where the vaccination is a condition of something. It may be a condition of coming into the office. It may be a condition of you may impose consequences such as testing, but usually this is consequences less than termination. Now, under federal, state, and local laws, as a general rule, unless there is a specific state law otherwise, and we'll be talking a little bit about some of those state laws, you can limit vaccine requirements to certain positions or activities. It's not an all or nothing decision. And so many employers are considering vaccine mandates or other restrictions, a hard or soft mandate for some positions, for some locations, for customer-facing issues, and not for others. Many other companies are saying it's easier and simpler and fairer just to mandate across the board for everyone, even remote workers. Next slide. So to give you some examples, the federal contractor rule is very clearly a hard mandate, and we're going to go into those details in just a second. Unless there is an exemption, federal government, federal employees, federal contractors will be excluded from contracts, and in many cases, that will mean that they are going to lose their jobs. The executive order for larger companies that Lisa will be touching on, this is the new OSHA rule that is at OMB right now, appears to be, based on the executive order, a soft mandate that you will be required as a larger employer to either have your employees vaccinated or to do mandatory weekly testing. But as we'll explore in our questions, there are a lot of questions about that. Next slide, please. So general rules, employers can mandate. That's the most common question we were getting throughout the last year. There's a long history of mandatory vaccinations in the United States. Those of you who've been doing your history or your reading know that some of the first vaccine mandates were in General Washington's army during the Revolutionary War for smallpox. There's a long history of it. There's a lot of law that dates back to the pandemic of 1919. And there's a wide history of required vaccinations for all kinds of industries. By and large, you tend to see this in the healthcare industry. All of you are familiar with mandatory vaccinations required for public schools and the exemptions that have a long history in this country. The U.S. military, any of you who have served know how many shots you were given. Sometimes you didn't know what you were getting. But there are a lot of states who are considering, and some who have passed restrictions on employers, and we'll be touching base on a couple of those. There's still one state, Montana, that has made being unvaccinated a protected class. Last year, there was legislation proposed in virtually every state that would limit or require vaccinations by various employers. And we are seeing a wide variety of mandates already at the state level or local level for different groups, organizations, entities, such as the Illinois requirements on higher education and secondary schools. But by and large, you have the right to impose these, just as you have the right to impose other safety rules. Next slide. Now, the EEOC's guidance from 2020, which they update regularly, is good law. It was often mischaracterized in the press as saying the EEOC says vaccine mandates are lawful. The EEOC never said that. The EEOC said, if you want to impose a mandate without violating federal civil rights laws, here is how to do it. And they gave that roadmap last December, and that is still good law, and it is an easy to read set of FAQs that most of you will have taken a look at one point, and that were just updated on religious exemptions on Monday, and we'll talk about that later. Most of your state and local laws that protect disability or religion will be interpreted consistently with that guidance. So if you follow the EEOC guidance, it is a good faith basis for saying you are complying with your state and local law, unless there has been some interpretation otherwise. And the concerns about emergency use authorization have basically disappeared. We have final approvals for adults on 2 of them and expected on J&J. And every court case that has come up so far where there have been challenges to mandates on various reasons, including involuntary medical experimentation or emergency use or other claims, have been dismissed. And so that the concerns about that have all but disappeared. Next slide. So one other caveat, as our friend Dan would tell us, is always a big caveat for labor relations issues. Your right to impose a vaccine mandate is on unionized employees is going to be subject to the any collective bargaining agreements, your management right clauses. It may be a mandatory subject bargaining, it may be an effects bargaining, but that will depend on your contract, your contact history, how your contracts are written. Next. So let's shift directly to the federal government contractor rule. Next slide, Mary. So the federal contractor rule, it is in effect. It is being rolled out already. This is the rule for the mandate, the hard mandate for all federal employees and for all federal contractors and all subcontractors on federal contracts. We are already seeing clauses that are being renegotiated, proposed changes. Many of you, or some of you may have already seen or had communications from the agencies that you contract with or prime contractors. The general principle is that federal contractors and subs are going to be treated the same as federal employees. That's because this rule is targeting service providers to the federal government, including all of those people who may work side by side or in federal facilities, but it's not limited to that. There are going to be new federal procurement rules. These are all being coordinated by OMB and actually being coordinated by the White House, which has a special task force just to implement this new rule. And these rules are going to apply across all agencies in all future contracts and may apply back to existing contracts. This is a hard vaccine mandate except for medical, disability, and religious issues. And there are also rules in there that aren't just related to the mandate. They're actually workplace safety rules for things like masking, distancing, cleaning. That's part of this rule as well, so that covered contractors are also going to have to follow other CDC workplace rules. In other words, this mandate incorporates CDC, some CDC workplace safety requirements and makes it part of your contract obligations. Next slide, Mary. So who's affected? It applies to all federal contractors and subs except, and these are the 2 big exceptions. One of them is for manufacturing of products. It doesn't, if all you do is make things that you sell to the federal government, this rule does not apply to you. If the prime is a small prime contract, less than $250,000, then it doesn't apply. But that's the prime contract. You may be an entity that is a subcontractor that only does $50,000 on a federal government contract. But if the prime is more than $250,000, you're going to be covered. We see this all the time in the construction industry. Even small construction contractors are going to be covered because the prime on the project is much larger. There is no minimum dollar threshold for the subcontracts, so it can be very small. But we're often asked about this. It does not apply to recipients of federal grants. Any kind of grants, federal financial assistance, money that is not a contract is not, the rule does not apply to that. Next slide, Mary. So the changes are already in effect. They are triggered in any contract awarded after November 14th, and with a very short time to get vaccinated. Many agencies are already notifying folks. It applies to new contracts. It includes, applies to any extensions, options, and the agency has, all of the agencies have the discretion to apply this retroactively. So you may get notice from an agency, even though you've got some time left on a contract, that they are doing a unilateral modification, which the contract probably almost certainly provides for, to add the vaccine mandate requirement. At this point, the best source of information on this is the various FAQs that are being updated by the White House. Next. So which employees are covered? This is the part that can get confusing. Let's just, we're just going to give you an overview of what you need to look at here. First, it applies to a covered contract employee. Basically, these are federal government contract terms. It can be either somebody who's working actually on a contract, they are billing to the contract, they are providing services that are billed directly or indirectly through the prime to a federal agency, or in connection with. And the in connection with language is used for all the administrative positions that support the contract in one way or the other. Large federal government contractors understand what this is because they are the indirect costs and the people working, doing marketing, finance, administration, other things. Those holding smaller federal contractors may only have a handful of people who are serving on the contract and not realize that HR and finance and legal and other people might also be covered because they work in connection. All of these employees must be vaccinated. Next slide. Then there's the ripple effect. The ripple effect is that once you identify that you have covered employees, everyone working at a workplace where those people work must be vaccinated, even if they have nothing to do with the contract. I may have 10 people in a 100-person office who are working on a federal government contract, but everybody in that 100-person office is going to have to be vaccinated unless they have an exemption, unless you can prove that they have no contact with anybody else. You have to basically isolate your contract employees from anybody else, which is not feasible. And if you control another location and somebody from your main office goes out there occasionally because that first person was covered at the main location, then other locations that you go to. This is why many federal contractors are moving in the direction of just applying uniform rules to everybody. Next slide. So who's exempt? Medical disability, religious exemptions under federal or state laws. And the executive order and the contract provisions do not define what these are. Basically, it's left to the discretion of the contractor to determine how they're going to apply their exemptions. Next. So how do you approach this rule? First, you got to know if you have contracts, and that may be easy in some workplaces and hard in many others. I'm familiar with higher ed institutions that are supposed to get all of their contracts reviewed through a central general counsel's office, but in fact, they don't do so, and not everybody sends them in. So you need to know what contracts you have. If it's subcontracts, figure out the prime, and then who works on them. And often HR, in a large organization that's billing, you know, because you have timesheets that are being reported, but you may have somebody else on fixed fee or services contracts that are not going through HR, and you need to figure out who's covered. Next slide. If you don't want to go the role of a uniform mandate, you then have to figure out how you minimize the number of employees that you have to get vaccinated. And you can do that if they are isolated, and it might be feasible. And you could reduce people going between workplaces to reduce those that are covered. This is going to get fairly complicated. And we don't know what, then the enforcement is going to be left to the individual agencies who are overseeing your contract. So this could be a difficult process. Next. And even if you already have COVID vaccine policies, you need to decide what you need to do. One of them is going to be to provide vaccine documentation. You're going to have the proof of vaccination from your employees. You're going to need to be able to provide it to the prime or provide it to the federal government. And that means you need releases from those that you have the vaccination from, because that's confidential information. And then if you are not here yet, you're going to need to impose the mandate. Next slide. So I'm going to turn it over to Lisa now to talk about what we think might or might not be in the OSHA. Actually, before I do that, Lisa, anything else to add on what we've covered so far?
No, I think we're all set to keep moving along. Thanks so much, Rob.
All right.
Next slide, please. Okay, so we've had a lot of questions about what is in the new OSHA rule with respect to large employers. What we know so far is that the coverage is intended to apply to employers with 100 or more employees. And we expect that in terms of counting and tracking, it will probably mirror other federal laws that are already in place when you think of the FMLA, EEO, and other similar rules. You're going to anticipate including your part-time employees, excluding independent contractors, things of that nature. An outstanding question is, will employees have the right to choose testing in lieu of vaccination? That's obviously the big question that we're waiting to receive guidance on right now. And again, as Rob said earlier, will the OSHA rule require that employers impose a hard mandate or a softer mandate with more flexibility? Next slide, please. So will medical and religious exemptions be needed? Unlike a hard mandate, if the OSHA rule simply just requires that all unvaccinated employees have to have weekly testing, then there's really no need to consider these exemption questions that we know that you're all wondering about, that we've been getting constantly, in terms of if someone raises a disability question or a question about religious accommodations. If you're simply going to enforce and allow weekly testing in lieu of the mandate, then you can just follow that protocol, which is a task in and of itself, of course, but you won't have to deal with as many hurdles regarding exemptions, because there's a much, much smaller population that require legitimate exemptions from the actual testing process. Next slide, please. So as we alluded to earlier, when it comes to the OSHA rule, what we're trying to clarify now and what we expect to have guidance on either literally, any day now, or certainly in the next few weeks, are the types of tests that are going to be required, the frequency, the cost, whether there's informed consent, and confidentiality. I do want to highlight that paying attention to who bears the burden of the cost of the test is going to be critical as you assess the needs and capabilities of your business moving forward. Obviously, right now, most individuals have the ability to go to their local pharmacy or a lot of different testing sites and get a free test. However, in the future, when testing is being done simply as part of an employer mandate, as opposed to a health-related reason, there's a question as to who is going to bear the burden of those tests. So we're waiting on more guidance there. And of course, in terms of confidentiality, maintaining accurate records that are confidential as to the results of those tests is going to be critical as well. Next slide. We want to also highlight, sorry, Rob, is there anything you wanted to add on?
Yeah, before we move on, Lisa, let's just make clear, these are two separate rules and they are going to overlap. Whatever the OSHA rule comes out, 100+ employees is a different rule than those applying to federal government contractors. We don't know a whole lot of details. The OSHA rule is probably going to get challenged the minute it comes, nanoseconds after it comes out. That may take a while to shake out. But the OSHA rule is going to provide a roadmap and details on all of those issues we just covered, and we don't know the answers to most of those questions yet on who's defined. Just as there are still open questions to be determined with the federal government contractor rule. But one of the things we do know is that the definition of covered employee covers anybody who's working on a contract, even if that is a temp employee or somebody else. If they're billing to the contract, working on the contract, they are subject to that, as well as other subs. Thanks, Lisa.
Thanks, Rob. We want to jump into factors to when considering vaccine mandates for employees. So let's move right along. Next slide. We hope that at this point, a lot of you have either already issued a survey or you're in the process of issuing a survey to get more information about your workforce in terms of who's vaccinated, who's planning to get vaccinated. And if employees are not vaccinated, delving into a little bit about why that is and being, of course, cautious about those questions. We always want to be careful not to go down the road of asking questions where someone is going to provide information about a disability, because questions related to specific employees' disabilities could be prohibited or restricted by the Americans with Disabilities Act. However, simply asking employees if they're vaccinated, if they're planning to be vaccinated, questions of that nature are permitted. We strongly encourage them. There's a lot of third-party sites like SurveyMonkey and others that you can use to very easily administer these surveys. We do recommend that you make these surveys mandatory, as I'm sure you can imagine. If you simply say to employees, hey, when you get around to it, can you let us know your vaccination status? Or we would, really like some feedback. A lot of people, that's going to fall to the bottom of their inbox, right? So we want to encourage you to make these surveys mandatory and to get them issued and to analyze those results as soon as possible. And also, of course, understand that once you have information, and we'll continue to touch on this, once you have the information about an employee's vaccination status, that should be treated as confidential, and you need to be very careful about who has access to that information. Next slide. We have received a lot of questions, and I know there's been a lot of questions in the media about what incentives, and we'll talk even about penalties that employers can provide in order to encourage employees to be vaccinated. We generally recommend and encourage clients to consider incentives instead of penalties. They're a lot easier to administer in most cases, and you have a few different options there. Including, of course, providing additional time to get vaccinated, additional compensation, which, by the way, in a lot of cases you're required to provide anyway, but even, providing additional compensation maybe on top of what's required under the law, providing transportation or stipends, bonuses, all of that, you should be considering and discussing with your counsel to the extent that you're going to issue those incentives. There are some caveats, though. Of course, if you issue an incentive now, employees who got vaccinated 6 months ago are going to have a lot of questions about, well, why didn't I get X, Y, and Z, right? And so we need to think through, if the incentive is being issued now and it's different to what was issued previously, why is that? What's your cutoff point going to be? How is that going to impact morale? Should the incentives be retroactive? But we do encourage you to consider all the tools available to you in terms of incentives. Next slide. The flip side of that would be to enforce penalties, to say, okay, you've decided not to get vaccinated, but here's going to be the repercussion of that. And while it is technically permissible in certain circumstances, it's much more difficult to administrate, and it can be hard to penalize. We saw an example recently that came out, it was a couple months ago now, but Delta Airlines imposed a penalty of raising health insurance premiums for unvaccinated employees by $200 a month to cover the cost of COVID. This was done under the rule of being included as a quote unquote wellness plan under the Affordable Care Act. So there were some exceptions there, which made this type of penalty technically legally permissible, but there's a lot of moving components there in terms of the Affordable Care Act, ERISA, EEO compliance. And so you should understand that to the extent you intend to go the penalty route, there's a lot of moving pieces, and it's really important to make sure that you don't step over the line with respect to any of these complicated federal laws, not to mention state laws or other executive orders that might be in place that might impact those decisions. Next slide. Of course, throughout this whole process, you should be performing a cost-benefit analysis in terms of employee retention. Of course, the goal is to encourage vaccination and to understand your population, how much of the population is vaccinated, who's intending to be vaccinated, in terms of returning to work, remote work versus in-person work. And then what are the implications of a mandate, right? So if you have the option to continue to allow testing as opposed to a mandate, what is going to happen to your workforce if you impose a mandate? We know that the labor and the workforce and the culture and the environment right now is that there's a lot of you looking to hire, and employees have a lot of choices. Candidates have a lot of choices about where they want to work. And so in terms of considering employee retention, you should, think about the culture of your workplace, think about who can continue remote work, what are the costs and versus the downsides to imposing a mandate, perhaps on employees maybe who are working remotely versus those who are only performing in-person services. Next slide. And then, of course, when we get to actually requiring proof of vaccination, there's a couple of different routes that you can take. The first one would be just the honor system, just, saying to employees, our policy is if you're going to come to work in person, and especially if you're not going to wear a mask, you're doing so because you've been vaccinated, and we're going to take your word for that. Frankly, as you can imagine, there's a lot of risk there, and that leaves a lot of room for interpretation. And as much as we want to trust and rely on all of our great staff and employees, you could run into some hurdles there. If individuals become sick, if there's an issue about whether a person is actually vaccinated and perhaps was not being honest about that. So that system is hard to verify. You could require an attestation or certification that from the employee that they are vaccinated, that they're affirming that they've taken those steps, so that you're getting them to confirm in writing what they've done, which, the implication there is that they're not going to be, perjuring themselves and lying through this document. The most common mode I've seen of proof of vaccination is just receiving a copy of the vaccination card. Now, we know that there could be situations or concerns about fraud, employees providing fake vaccination cards or cards that have been modified. But in general, this is probably the easiest standard to at least start with, because you have an understanding of what the card would look like and what information you would need to see on that card. And then there are going to be some state and local localities throughout the country where you're going to have a system established by the government, an app or something like that, where you can easily verify who has actually been vaccinated. In terms of considering, fraud prevention, one option that you can have is to combine these methods, right? So have the actual copy of the vaccination card along with the attestation that the employee is certifying that they've been vaccinated. So you're, having both methods, and it's easier to discipline or take action if you come to find out that there has been an employee who's provided fraudulent information to the company. Next slide. Confidentiality. We've talked about this. We're going to continue to highlight it because it's really, really critical under federal and state employee protection laws. Vaccination status is confidential information. So while simply asking someone if they're vaccinated is not a disability related question, once you have the information that someone is vaccinated, that information needs to be treated in a confidential manner and can only be shared with individuals on a need to know basis. So it might be supervisors or other individuals who are imposing, for example, mask mandates or other safety protocol based on who is and is not vaccinated. But it's really critical that you have a clear policy in place as to who's privy to that sensitive and confidential information. Next slide. Rob, anything you want to touch on here?
Yeah, just add a couple of things on those slides and cover a couple of the questions. On confidentiality, for any of you who are going to be subject to a mandate, federal government contractor mandate, to provide that, I would start collecting that information now, but there's no need to turn it over until you are requested. That was one of the questions. There is nothing wrong in asking employees to waive their ADA confidentiality rights to enable you to share that information where required. There's a good argument that if your federal government contract requires you to turn over those vaccine cards to the federal agency or prime, you have a right to do that because federal laws, one can supersede the other. But I would just get the release, and you'll have other situations where you may need to share that with customers or other places that are requiring proof of vaccination. So you can legally ask for it. Now, if the employee won't consent to doing that, then you may have to limit where they can work. They may not be able to work on that contract if they don't allow you to go ahead and do that. And if you missed it, the HHS about a month ago came out with a very simple couple-page explanation as to why nearly everything that people think are covered by HIPAA is not. This is an ADA issue only for confidentiality. Thanks, Lisa.
Thanks, Rob. Next slide, please. Okay, so we're going to continue to highlight that there's many different pieces of the puzzle here, and we need to dot our I's and cross our T's when it comes to checking and coordinating with local laws and rules. We have obviously the federal law, executive orders, OSHA rules, and the federal level of guidance that we've been talking about. But then there's another layer, which is, does the state where the employee lives or works prohibit the employer from requiring a vaccine mandate? Currently, there are prohibitions in Montana and Texas in terms of private employer vaccine mandates, which are in various forms being challenged to some extent. And then there's many more areas that are prohibiting vaccine mandates for state employees only, as opposed to the private sector. And then we have states actually on the flip side, like New York, that are, basically requiring people to provide proof of vaccination almost everywhere you go. So it really depends on where are your employees working. And as we'll talk about throughout the presentation, this includes remote employees, right? So if somebody is working from home or at a remote work site, what laws and rules apply to them as well. So be really mindful that there's multiple different layers in our checklist when we're thinking about implementing these policies, and what's permissible in one region might be different in another. Next slide. As part of this analysis, you need to determine which of your employees are going to be subject to the vaccine mandate. So we've seen some companies and clients that are mandating vaccination for everyone across the board, no matter where you work. And it's just for purposes of keeping things consistent, applying the same rules and processes to everyone, so that in the event you do have employees interact or overlap, you have the same processes in place, that everybody is vaccinated, and you don't have to worry about having a second set of rules or encountering issues down the line. However, it's more common, and I think what we see more often is that we're going to focus on the vaccine mandate for employees who are actually reporting to work in person, or for people who are interacting with the public, or in healthcare services, obviously people interacting with patients. It's going to be very difficult for those individuals to demonstrate that they don't need to be vaccinated. And in most cases, that is already required, subject to the exemptions that we're going to discuss. So think about what portions of the population you're targeting, and make sure that your policies are specific to those portions of the population. And as we say here, any policy that you roll out during COVID should have a caveat that this is your approach at this time, that is subject to change. This is a moving target. We've seen many iterations of these rules come out. It's a developing issue, and you need to have that flexibility. Your employees need to understand that these rules are going to change over time. Next slide, please. So this whole concept of determining which employees are going to be covered by vaccine mandates certainly applies in the realm of in-person service providers. We already know that hospitals, nursing homes, and healthcare providers were among the first to be subject to these rules. There are a number of local laws we just want you to be aware of. To the extent that you have a contract, work with, or employ anybody in these positions, a lot of cities and states are requiring that people in these roles who perform these services are vaccinated. So even if you're a private entity and you have not enforced a vaccine mandate across the board, where the employee is working, if it's work for the government, they may require a vaccine mandate. So you should expect that we're going to see in most areas of the country more and more of these vaccine mandates roll out across the board. Next slide. Okay, so when and how are you going to require vaccine mandates if you haven't already done so? You want to be clear in your policies that you're going to, first of all, you should provide advance notice, right, to give people time to get vaccinated if they haven't, or if they're in the process of getting vaccinated. You want to have that hard deadline, which of course you can always modify, but you want to give people a deadline to get vaccinated. You want to describe the process of requesting an accommodation, who that request should be sent to, and where they can find information about what is needed to be provided as part of that request. This is not a situation where an employee is saying, I have a disability or my religion prevents me from getting vaccinated is enough. We assume that most of you are aware of that, but that is not where the buck does not stop there. It's a much more involved inquiry, and employees need to be aware of that from the get-go. We also want you to be aware that, of course, there's a lot of information out about boosters right now, and more boosters are going to be coming available in the near future. Do not worry about boosters right now in terms of your vaccine mandate policy. You do not need to require at this point that employees have their vaccine plus a booster in order to return to work. We're going to get more guidance about boosters down the line, but you don't need to incorporate that in your policies right now. Next slide. Okay, third-party rules. We have also received a lot of questions about this. If you are an entity that has a lot of third parties, contractors, vendors coming to your site, and your question is, okay, we're requiring vaccine mandates for our employees. We have very strict safety policies. What about all these other people coming into our facility? Well, absent a state or local law that restricts you from putting in place a vaccine mandate, you can require vaccination as a condition of being permitted onto your facility. There are going to be questions about what that proof looks like and where you're getting proof or confirmation from those individuals. But as a rule, you can require that employees who are coming, or I'm sorry, third parties, vendors, contractors coming to your site, visitors, you can require vaccine mandates across the board. Next slide. And Rob, I didn't know if you wanted to add anything after that section.
Thank you, Lisa. Now I'm going to tell everybody to take a big, deep breath. And let me just pause here and say, vaccine mandates and what you're going to have to do with them, they're going to come in all shapes and sizes. If you are a federal government contractor or a sub, you're going to have to sort out what's required and what's not on those particular contracts under those rules. If you have 100+ employees, you're going to have to sort out the OSHA requirements. If you are a higher ed institution in a state like Illinois that is requiring vaccine mandates under a state executive order, you have to sort out what's covered and what's not there. If you are a healthcare provider under the Medicare HHS rules that were issued several months ago, it's a separate set of rules. If you are a provider of services to a city like Philadelphia that requires contractors, it's a different set of rules and requirements. There are some general principles, and if you're not covered by any of those, or even if you are and sorting things out, you can impose your mandate on your own broader than the minimum number of employees who are covered. So you have a lot of things to sort out depending on your size and the nature of your workforce, and whether you want to just do a hard mandate for everybody absent the exemptions. So this is not a one size fits all. One of the questions we got was, I have a franchisor requiring its franchisees to get vaccine mandates. That's going to be purely a question of the franchise agreement and whether or not they have the power to do that or not. And that's not related to any of these other laws. So let's spend just a couple minutes on testing, because under at least the OSHA rule possibly, and under others, there are sometimes options to do weekly testing, or you may choose on your own, if you can, to say, I want to do testing rather than a hard mandate, because otherwise I'll lose too many people. So let's talk about some practical issues. Next slide, Mary. If everybody I know who's already looked at this has said, this is going to be a big pain if I have to do weekly testing, particularly in those areas, some industries, some employers that may have upwards of 20, 30% or more of their employees who are still unvaccinated. OSHA rules may give us a lot of details on this, or they may not. We don't know how specific they will get. But any testing program that you choose to do needs to think about the types of tests, when, where, how, whether people get paid, who pays for the cost of the test. Next slide, Mary. So as a general rule, under the FLSA, it is likely, and there's been no specific DOL guidance on this yet that we've seen, that you're going to have to pay hourly non-exempt employees for the time they spend getting tested. There are similar and analogous rules for other kinds of medical tests that are required as a condition of employment. Again, we don't have specific DOL guidance on this, but there's some fairly extensive past guidance you and your lawyers need to look at. It is possible, and there is buried in the DOL, a de minimis exception for tasks that take less than 10 minutes. Next slide then. And that could apply to the rapid tests. Who pays? Well, these are still free as a general rule when they're taken, but it's unclear whether it's going to remain so or whether there are copays or other issues. The only thing we have so far is the OSHA rule for in healthcare that said that there could not be any cost to the employees. That's for the cost itself. There's also language in the EEOC guidance that alternatives to such as testing to alternative accommodations or alternative methods to accommodate somebody's disability or religious exemptions. You know the old rule, you can't have employees pay for accommodations. So if the testing is the alternative to their exemption, you may need to pay for it under the EEOC guidance. Next slide, Mary. Which tests? Look, rapid tests and antigen tests, easiest, cheapest, but then you have to figure out how to verify it. And are you going to do it at the workplace? Are you going to have employees do it at home? Do you trust them not to lie? Do you want to do video verification, watching them take the test? There are rapid tests available from healthcare providers that are more reliable and more expensive. And of course, the PCR tests, you're going to have to wait for results. I was talking about this with a physician friend, a colleague of mine. on what it could mean if millions of employees suddenly need to be tested weekly and the demand for that and how long the labs are going to be burdened. And he said, well, I think you should have the tests administered on Wednesdays in order to be ready for work on Monday. I said, why? Well, that's our lightest day for most healthcare providers midweek, but you're going to have to, it's going to get complicated. Next slide. When and where to test, we just covered this. At work rapid tests, one possibility, but can you see everybody standing in line waiting for their rapid test results in the morning, sitting around and sending the others home? Can you really accommodate that in your workforce? Next slide. So you are allowed to do these tests under the ADA as job-related and consistent with business necessity. But this is one of those places where the EEOC guidance in its FAQs on testing actually cross-referenced the CDC rules on informed consent, which takes in the whole question of disclosures to employees on the test, the consequences, the accuracy, and what's going to happen. And you need to treat the test results as confidential, and you need to figure out what to do with the tests, the test strips if you're doing them on site, or the test kits. Now you've got medical waste, which implicates EPA rules potentially on medical waste that you have in the workplace. So it is complicated. Next slide. And then if you do more testing, you're going to have more positive results. You're going to have to do contact tracing. You're going to have to isolate people and follow the CDC guidance on that. Next. So it's just difficult. So what about other requirements? Next slide, Mary. As a general rule, under OSHA may say that you have to, as a general rule, the unvaccinated are not a protected class, except in Montana right now. And as a result, you can impose other requirements. The EEOC is clear about this, is that even if somebody is unvaccinated, you can impose other requirements on them. Remember, when the rest of us were allowed to take our masks off, EEOC would have said it is perfectly fine to require the unvaccinated, pursuant to CDC guidance, to continue wearing masks in the workplace when others people don't. Next slide. So common requirements on the unvaccinated, or including but not limited to those who are under exemptions: masking, social distancing, or even excluding them from the office, excluding them from in-person events, excluding them from any events where food and drinks, where masks are going to be off. All of those are legitimate safety rules to protect both the unvaccinated people and others from transmission and from breakthrough infections for our vaccinated employees. Next. So now the fun topic of disability religious exemptions. Next slide, Mary. The disability, we tend to lump all these together, but all the principles for these exemptions are basically ADA and Title VII religious and disability accommodation issues. All of you are familiar from the past with making accommodations for employees with disabilities, for making religious accommodations, or a process for employees seeking exemptions or anything, time off for religious purposes. Follow those procedures. The principles of this are no different, and the EEOC is citing back to its other guidance in under the ADA and Title VII. Now you're just applying it to something different. So one of them is disability exemptions. In fact, and this is really anybody with an ADA covered disability, which is a pretty broad definition. But the CDC has recommended the vaccine to almost everybody. The list of people for whom the CDC does not recommend the vaccination is very, very small, primarily those with severe allergic reactions. They say that everybody else can and should get it. Next slide. But you will have some people who need deferrals because they've just had COVID. And the CDC now recommends pregnant women get the vaccine, but that's different. So most of the medical exemptions you get, most of the employees who say, I don't want to get the vaccine because of, or I can't get the vaccine because of this medical condition, it's not going to be contrary to CDC guidance. They should, but they may have a doctor that writes them a note. So here's the question: what's your tolerance on the notes that you get? Are you going to want to go contrary to the doctor's recommendation, or rather do you want to say, okay, I'll accept this conditionally at this time, and I'm going to revisit this in 60 or 90 days. And that's one way to deal with the exemption right now, because you can go back and look at it again later. The EEOC clarified that in its brand new guidance. Next slide. So other medical requests, we think you can ask the doctors to say which CDC principle applies. And when you ask that question, they will typically, drop their entire request because it's not contrary to CDC recommendations. But you'll have to decide internally your tolerance for complaints or claims later and whether or not you want to push back on doctors' notes you receive or just grant the medical exemption. Next slide. Now into the religious issues. I think everybody's familiar with the fact that we are getting inundated with religious exemptions. EEOC principles are basically going to be the same as those under state and local laws. There is a lot of law on this, and the EEOC just provided some additional technical assistance earlier this week. Next slide, Mary. So the two-step process, and by the way, this is your first CLE code. Look at that there. If you're seeking CLE, your code number is 13572. I repeat, 13572. Now, two-step process. Think about it this way. Is this request based on a sincerely held religious belief? If it isn't, it can be denied, period. The second step, if it either is a sincere religious belief or you don't want to argue about that right now, can the exemption be accommodated? In other words, what are the alternatives? Is remote work possible? Can I keep people separate? Is masking and weekly testing sufficient to minimize the risk in my workplace? Or am I going to take the position that because of the nature of the work, I can't accommodate somebody without posing a more than de minimis burden and elevated safety risk on coworkers or customers, and therefore I'm going to terminate this employee or take other adverse action. But these are two separate steps. Next. So religion, very, very broad. When you look back at the EEOC technical guidance from Monday, it really just parrots what's in their case processing manual. And that is to say, traditional principles are that Title VII religious protections are very broad. It can apply to religions you've never heard of. It can apply to small groups of people that believe something that's different than the denomination or sect or faith that they profess to be a part of. It can be a small group of people only that have something completely illogical or unreasonable to most people, but that is what they believe. If it is religious or spiritual and based on a belief in a higher power, it is religious. And you can't just be skeptical and say, I've never heard of this, or this is not a mainstream religion. Next. However, this is the one we're dealing with now. Social, political, economic, personal preferences, these are not religious beliefs. Religious belief has to be spiritual. It can't just be anti-vaccination. The EEOC's technical assistance gives some examples of this. Just one of the specific languages that's going to be very, very helpful to us on this is that concerns about the safety and efficacy of the vaccine, or feeling that I don't need it because I'm a healthy young person or I've had COVID before. Those are personal preferences. Those are health and safety issues. Those are not religious beliefs, no matter how much it's been cluttered with religious language and citations to the Hebrew Bible and the New Testament. No matter how many quotes there are in there, they are still based on safety or efficacy or personal liberty and freedom. Those are not religious beliefs. Next slide. So here are some of the examples. If you see constitutional claims, liberty issues, if you see complaints about involuntary testing, or I don't need it, and a lot of these objections are based on misinformation, false information about the vaccines themselves or their efficacy. Those are not religious, and you can deny under step one on that. Next slide. This is the same. This is basically the slide. You can go back to it later. Is whether it's really the same belief system as others. Next slide. So here's the question: how far can I push back under the new technical assistance? More than you may feel comfortable doing. A lot of employers are uncomfortable challenging religious beliefs, but you can. If you have an objective basis, you can do so. We're finding and hearing anecdotally that if you have the time, interviewing somebody about their objections, most people are going to dig a big hole for themselves and reveal that this is in fact an anti-vaccine or just an anti-COVID belief rather than based on a religious belief. But more often people are requesting supplemental statements on that. You can question when you have an objective basis. Next slide. And a lot of this pushback that people are doing and that we are advising you can legally do is whether this is a consistently held sincere belief, whether or not they have made similar objections in the past, whether or not they've ever given vaccinations to their kids or objected in the past. For many of these claims, you'll find that this is the first time the individual has ever refused medical treatment for a particular reason. But one of your alternatives when you're sitting there with 200 of these requests is to say, okay, we're going to accept this at this time, and we'll reserve the right to push back later, and then move on to the next step of undue hardship. The last step, next slide, please. And the last step, oh, here's some of the possible questions. You can go back and look at this. Have you had prior vaccinations? Have they had other treatments that are considered invasive? Have they ever investigated in the past or in the future the use of fetal stem cells and the development and testing of all the drugs that are on their shelves? The answer usually is going to be no. Next slide. Then you have to think about alternatives. And before you can fire somebody, if you get the exemption, you have to go through what's the burden of doing the alternatives or allowing that person in the workplace if you decide to accept it at this time. Next slide. This is where the EEOC guidance this week is helpful to us. Some very good language on undue hardship based on health and safety issues and the ability to weigh health and safety concerns as a factor and ultimately to exclude somebody from the workplace if other alternatives aren't available, such as remote work. Next slide. So you have to go through the process, however, of saying, can this person do remote work? What's their risk? Are they customer facing or are they on their own? How many other people are vaccinated? How many other people in the workplace are not vaccinated? All of those you need to be able to do. And at the end of the day, if you're going to say, no, I can't accommodate somebody, you just have to be able to defend that conclusion as to why they're an elevated risk. Next slide. And just note, just the fears of everybody else in the workplace are not enough. Prejudice against somebody who has a religious exemption or disability is not enough. You have to base it on objectively on the safety risks or on the other burdens. Next slide. That's it. And my apologies to my next presenters for going 5 minutes over. Thank you all very much.
Lisa, thank you so much. I know that we addressed some of the questions that we could, both in the question and answer boxes and live. We're going to now turn it over to Steve and Lisa for our next topics. For those questions that we didn't answer, just a reminder, we will stay after the presentation to try to address some of those questions, and we'll continue to address them in the question and answer box. Okay, remote work during and after COVID-19. Lisa and Steve, take it away.
Okay, thank you, Dina. And if we could go to the next slide, please. We're going to start actually pre-pandemic. Basically, remote work isn't a new thing, but it's historically has not been as prevalent as it is today. Obviously, in March 2020, employers were forced to revision what the workplace looks like as shutdown orders forced most non-essential workers to work from home. And now post-pandemic, as you can see on the right here, some statistics, remote work is much more prevalent than it has been in the past. If you could go to the next slide, Mary. So 2021 has seen some welcome developments for employers with regard to the easing and lifting of state and local capacity restrictions, which have allowed a return to the workplace. Despite this, a variety of major companies are planning to continue remote work. For example, Amazon, Google, and Lyft have all announced that most office workers will not be returning until 2022. And many employers are providing employees with flexibility to work remotely at least some of the time. In addition to the safety benefits that come from this, it's also pretty popular with employees. Surveys are demonstrating that most employees prefer the ability to work remotely at least some of the time. And these statistics to me are just staggering. Glassdoor has indicated that candidates seeking remote work grew 460% from June 2019 to June 2021. And according to flexjobs.com, 58% of workers said they would look for new jobs if they cannot continue working from home in their current role. So there's likely to be a transition period through the coming year as businesses continue to experiment with an appropriate mix of work from the office and remote work, but it's likely to be here to stay in some form for most employers. Okay, next slide, please, Mary. So there are some benefits to remote work. Obviously, employee morale and work-life balance. There are potential cost savings to employers, and reduced overhead is always a good thing. There's the ability to recruit employees from other marketplaces, candidates who may otherwise have not seemed, like good or even potential candidates or fits. It also incentivizes potential job candidates who view the flexibility of remote work as a benefit in their job searches. And then finally, there are some societal benefits such as reduced traffic, greenhouse emissions, and so forth. If we could go to the next slide, please, Mary. Now, there are some drawbacks too. First of all, not everybody can do it. Depending on the job or the industry, it may not be feasible. For example, people in healthcare, hospitality, construction, for example, often have more difficulty working remotely. Second of all, it can be detrimental to fostering camaraderie and workplace culture. And this is a big concern for many employers. It's just more difficult to get to know and trust your colleagues if you're not sharing the same office space with them. Additionally, newer hires can be overlooked or passed over for new opportunities or for work simply as a function of low visibility when people aren't sharing the same office space. Another drawback, less employee supervision. It's obviously more difficult to tell what an employee is doing with their time when they're not in the office, and some employees take advantage. Not all. I think that, generally employers have found that employees can be just as effective remotely. Nevertheless, supervision can be a concern. There's less control over how confidential and trade secret information is handled, which is problematic for reasons we'll discuss a little later on. And there's lots of traps for the unwary when it comes to complying with applicable laws. Depending on the length of the relationship where the remote workers are stationed, you could have the laws of numerous jurisdictions, some of which you're just frankly not familiar with, applying to your remote workforce. So that's something we'll discuss in just a minute here too. Mary, next slide, please. So we're going to talk about a scenario. And this involves our friend Charlie at ABC Corp. Charlie's a non-exempt administrative assistant, and under ABC's flex work policy, employees are encouraged to come into work, but they're not obligated to do so. Despite the encouragement to come into work, Charlie has been fully remote for 3 straight months, and his work performance during this time has been nothing short of stellar. He's available first thing in the morning and all through the day, and he even attends to emails late at night and on the weekends when he otherwise would not be expected to do so. So, Lisa, it sounds like Charlie's killing it performance-wise. It's probably not great that he's not coming in when there's the encouragement to come into work. But what are your thoughts? Does this scenario raise any red flags?
Great question, Steve. And I think that, we probably have a lot of clients who encounter this kind of scenario where, when somebody is working remotely and the work product's getting done, I think that that's the most important thing, certainly from a substantive standpoint, but what other questions do we need to ask? So let's think about that. Next slide. Well, when we talk about Charlie working from home, we need to remember that Charlie is not exempt. And so he is entitled to overtime pay under federal and probably state wage and hour laws. So even though it seems great that Charlie is working really hard and he's getting his work done and he's getting it done and, really quickly, how many hours is Charlie working in a week? And is he going over 40? And even if he's doing it from the comfort of his home office and he's really happy to be there and really comfortable, once Charlie works more than 40 hours, or if he's in some states like California, which have different overtime laws where overtime might even be required if he works more than 8 hours in a day, we need to make sure that Charlie is being paid appropriately. I want to say one thing very clearly. Just because an employee is paid a salary does not make them exempt. You need to be paid a salary and perform exempt job duties. That's a really common question that we get all the time. And a lot of people unfortunately incorrectly assume that paying salary is enough. That is not the case. And it doesn't matter how good someone is at their job. It doesn't matter how much you value them. If they are not doing exempt job duties that meet certain specifications under the law, they have to be paid overtime. So we need to think about tracking Charlie's time. Is Charlie, submitting a weekly timesheet? Is he somehow verifying the hours that are worked? We cannot just assume that somebody is working 9 to 5 if they're non-exempt. We need to know actually how many hours they're working, including any breaks. Next slide. So when we think about other potential legal issues of remote work, we want to make sure that we're not stepping into any potential discrimination claims. We want to apply our remote work policies and opportunities uniformly as possible to all employees in similar roles. So if Charlie's allowed to work from home, but Susie is not, and they do the same job and have the same title and largely the same job duties, why is that, right? We don't want there to ever be the perception or the inadvertent, policy application where people in one group are allowed to do something and people in another group or in a protected category don't have the same benefits or leniency. So we want to be consistent. And of course, we also want to always make sure, and this is particular with respect to new hires, that we're continuing to follow all immigration and I-9 policies that we need to. Just because someone is working remotely does not mean that those laws don't apply and you don't have to worry about collecting that paperwork. It's still just as important as if they were coming to the office. Next slide. A really big area of potential risk, if not handled appropriately, is compliance with state and local laws with remote workers. And again, we need to think about if somebody is working remotely and that's their position, and it's not just a temporary situation where they happen to be remote right now because your building's under construction or you closed down for 1 week due to a COVID cleaning and now you're reopening. If they're really a remote position, the laws that you need to consider are the laws of the state and the city where they are working. So it might be really great and convenient for your company that now you can hire employees all over the country because you realize that they actually can do the work remotely and you don't actually have to look in, let's say, Philadelphia. You can look in California, you can look in Texas, wherever. That's great. But what laws apply to those employees? How are they paying their taxes in terms of their pay stub? Are you following the appropriate new hire processes? So as much as it's a benefit to have remote workers, as we've said, we know that logistically it's really nice and maybe it's great, to a great impact on the footprint of your office. Maybe you don't have to rent as many office spaces. That's all well and good, but you're going to step into hot water real quickly if you are assuming that, your one size policy and handbook for your corporate office is a one size fits all for all staff, because that's not the case. Next slide. And where we see this come up in particular, and what we hope everyone is aware of and continues to be aware of, is specifically with respect, other than overtime, I would say the biggest question we get is about leave laws, unpaid sick time, and things like that. So from a starting standpoint, everyone should be aware that more and more state and local jurisdictions are requiring paid sick leave for employees who work in those areas. I can tell you as an example, by the way, if you do any business in California, kudos to you, just, in general, but you should know that the sick laws are not just statewide. There's local sick laws depending on where in the state you work. Most other jurisdictions, it's specific to, either a statewide law or only specific cities. So in Pennsylvania, there's a Philadelphia paid sick time ordinance that is not statewide, but if you work in Philadelphia, it applies to you. In New York, there's now statewide paid sick leave. So again, it depends, but it's all about where is the employee working, not where your corporate headquarters is located. And so you want to make sure to check your policies, make sure you're in compliance. And if you do transition a role or hire someone newly in that position, a lot of rules, by the way, require that on day one of employment, that employee starts accruing paid sick time, right? So maybe they're not able to use sick time right away, but they need to have a bank showing that they're accruing, or you're giving them a sick time in a certain amount from day one. In most places, that's 40 hours for the year, but it does vary by location. And then just be aware of making sure you have your workers' liability and workers' comp insurance in place for all areas where you're doing business, and that you're providing proper notices that are specific to state laws to all employees based on where they're working. Next slide. Okay, we want to throw another scenario at you that we think is really relevant to this day and age. Jean is a senior associate at XYZ LLC, a venture capital firm. Given the flexibility that comes with remote work, she sometimes sets up her laptop to work from a local coffee shop. On Friday, she had a Zoom call with the CEO of her employer, Anne, and Jean participated from the coffee shop. The purpose of the call was to discuss Jean's due diligence regarding a potential investment. Jean wore headphones so that no one could hear what Anne was saying, and no one appeared to be around Jean during the discussion. During the call, Anne asked about various details regarding the target's finances, and Jean could readily answer them with the help of the spreadsheet she had printed out in advance. Anne left the meeting with everything she wanted and expected of Jean. Sounds great. Jean was prepared. She had her printed spreadsheets. She was ready to go with the answers. Steve, should Anne be concerned about the way Jean conducted herself during that Zoom meeting?
Yeah, not with regard to the content, but certainly with regard to the judgment in the manner in which it was communicated. Here we've got a scenario where whether or not they could hear Anne, they could certainly hear Jean talking in the coffee shop if they were close enough. Second of all, she had a laptop up. When Anne was not on the screen, it was likely that, confidential information in preparation for the call was, and it's possible that, people walking by could have seen that. Third of all, she printed all this confidential information and had it on the table while she was talking to Anne. So, that was presumably there before and after as well. Who knows who could have walked by and seen it? Who knows if Jean left it unattended? I think that Anne would be justifiably concerned about the way that Jean handles confidential information in general on the basis of just that one exchange. So as this scenario demonstrates, and I think we can probably go to the next slide now, please. There are really a lot of issues that remote work can pose with regard to potentially sensitive information getting disclosed, whether it's voluntary or involuntary. As employees access confidential information remotely or remove confidential information from the office, employers lose a certain amount of control over what is done with that information. This could pose a competitive risk if the information relates to customers' competitive pricing, something else that if it was in the hands of a competitor could be beneficial and lead to a loss of business for the employer. There's also potential ramifications in terms of statutory compliance. There's myriad statutes that apply to certain categories of information. You've got HIPAA with regard to health related information, FERPA with regard to student records, Gramm-Leach-Bliley with regard to financial data of financial customers, and then also just consumer privacy acts that are being passed really around the country that may protect this information. So there could be statutory violations in connection with remote employees if they're not careful with what's being done with confidential information. Also, confidentiality obligations to third parties should be kept in mind. Here, it's very, very likely, almost certain, that there was a non-disclosure agreement in place between Jean and Anne's company and the target that they were discussing. So could that have been breached by means of that conversation? Possibly. So we need to keep in mind that employers often have confidentiality obligations to third parties that need to be attended to. Okay, if we could go to the next slide, please. So avoiding some of the legal and practical problems of remote work, we've already discussed ensuring that the company is on top of all potentially applicable laws at every level. And also it's important to ensure that employees are bound by appropriate confidentiality agreements and other restrictive covenants that are necessary to protect employers' legitimate business interest in their confidential information and goodwill. With regard to, kind of some of the behavioral issues that can pop up in remote work, it's very important to clearly and repeatedly communicate expectations to employees, both verbally and in writing through means of a formal written remote work policy. And then that policy should be applied uniformly to all similarly situated employees to avoid scenarios in which it could lead to claims of discrimination. If we could go to the next slide, we'll talk about some components of effective remote work policies. Really, the first thing that a remote work policy should do is define who is eligible for remote work. Remote work policies may be, or remote work may be appropriate for certain positions and not for others. So employers should document in their policies, what kind of position is appropriate for remote work and how often remote work will be available. Is it part-time, 2 days a week? Is it full-time, et cetera? Since each position has different job-specific requirements, team-based activities, there are key differences to keep in mind when deciding what kinds of positions might be eligible. And employers may wish to set eligibility requirements that include, for example, years of service. Is this a benefit that's being offered to more senior employees? Is this something that's going to be available to full-time employees, but maybe not part-time employees? Is this something that's going to be available to people who have sterling disciplinary records? It's important to set those eligibility criteria and make it clear what they are. Regardless, any remote work policy should specify that it's a privilege that may be, revoked, and that the remote work policy can terminate at any time. That provides the employer with some flexibility should business or operational needs change. An effective remote work policy should also specify how often remote work is allowed, depending on operational needs, collaboration, workforce culture. Employers may choose to limit that. And with regard to the duration of the policy itself, employers may choose to set a time frame on that. For example, does it apply only in the context of a government declared emergency like the COVID pandemic? Expectations should be clear there. Employers should also reserve the right to call employees into the office on what would otherwise be remote days should the need call for it. That again provides for some flexibility. Remote work policy should describe the procedures with regard to remote work, how to request it, who must approve the request, how that request will be handled. Again, that helps to set expectations. And speaking of expectations, a really crucial component of a remote work policy is informing employees of what's expected of them while they're working remotely. They must be able to carry out the same duties, assignments, and work obligations that they would otherwise be performing in the office. They must be available to their supervisors, to their managers, to their colleagues, and the means by which they must be available should be specified too, whether it be telephone, email, video conferencing tools used by the company, or all of the above. And employees also need to be available to attend regularly scheduled meetings and participate in other required office activities, whether they're on-site or off-site. Policies should also spell out that employees need to devote their full working time and attention to work. Obviously, working from home can have its distractions, so employers should remind employees that remote work is not designed to be a replacement for dependent care or unless otherwise agreed to provide flexible working hours. Now, there may be reasons why an employer would want to do that, but if that's not the intention, it should be made clear in the policy. Application, let's go to the next slide and talk about the application of other policies. The remote work policy should specify that all other policies continue to be binding, and that violation of those policies of the remote work policy could lead to termination of a remote work scenario for that employee or other disciplinary action up to and including termination. We talked about the recording of time earlier with regard to Charlie. Very important that time be kept, and overtime should be pre-approved by the manager. That should be spelled out in the policy too. Equipment costs and home office maintenance and supply subsidies. Expectations with regard to that should also be set in the policy. Notably, some jurisdictions require necessary expenses to be covered by an employer. In others, you've got more flexibility. So keeping on top of that law and deciding what's going to be covered and communicating those expectations to employees is helpful. Permissible locations, harking back to Jean and Anne, you probably want to specify where employees can be working remotely. If they're in possession of and using confidential information on a regular basis, you want to make sure that that's in a secure area and that we don't have the potential issues we had in that scenario. Also, the geographic locations. As we've talked about, there may be different laws that apply. So making sure that expectations are set with regard to where work is being performed would be helpful. Security and confidentiality, myriad, protections you can include in your policy along these lines, using secure wireless networks, VPNs, regular password maintenance, up-to-date virus protection, up-to-date, software upgrades, you name it. Also important to include in your policy to the extent that that's a priority. And finally, safety. You want to make sure that, remote work stations are safe and that employees are reporting remote work injuries. There may be workers' compensation implications in your policy, though you want to specify that workers' compensation does not apply to third parties like family members who are injured at an employee's remote office space. And with that, we'll turn it back to our moderator, Dina. Looks like you're on mute, Dina.
Thank you. I know everybody sees me and gets nervous, like, oh, I have to wrap up my presentation. So thank you very much, Steve and Lisa. We are going to take a 5-minute break for everyone to stretch their legs, grab a cup of coffee, use the restroom. We will be back here promptly at 10:30 to continue with the next part of our program, which will be long COVID as a disability under the ADA. So see everybody in about 5 minutes to continue the presentation. Thank you.
Hi, Dina. I thought I'd keep you company for a minute.
Thanks. Thanks, Gary.
We're getting some really great questions, and I know we're going to handle at the end.
We are. We actually, for everybody who's been sending questions in, we're trying to answer them as we go. Some of them we are touching in the live material. So I've been answering those as we go and just indicating we're answering them live. We are keeping a running list of the questions so that at the question and answer session at the end, we will answer those questions to the best of our ability. And then there are some that are going to take a longer answer. So for individuals who want to take that opportunity for 10 minutes with one of our attorneys, please just let me know that and we will schedule you for that separate time after today.
Terrific.
Great, Chris. I think we can go on to the next slide presentation. I would like to introduce Antoinette and Alex, our next presenters, to talk about ADA, long COVID as a disability.
Hey, thank you, Dina. COVID-19 has been around since at least March of 2020, and it seems that it will be around for a little while longer. Fortunately, we have effective vaccines, which means more people can survive COVID-19. But with that, more likely there will be long haulers. That is, people who will have long-lasting effects of COVID-19 or long COVID. As explained by the Centers for Disease Control, although many people with COVID-19 get better within weeks, some people continue to experience symptoms that can last months after first being infected, or they may have new or recurring symptoms at a later time. The CDC has specifically stated that, quote, post-COVID-19 conditions are a wide range of new, returning, or ongoing health problems people can experience 4 or more weeks after being first infected with a virus that causes COVID-19, close quote. These conditions can happen to anyone who has COVID-19, even if the initial illness was mild. Interestingly, even originally asymptomatic patients can have post-COVID-19 conditions. Next slide, please, Mary. Long COVID is also known as post-acute COVID-19, the long-term effects of COVID, or chronic COVID. According to recent research, more than 11 million people nationwide are living with long COVID, and that between 10% and 30% of those infected with the coronavirus will suffer from long COVID. It's really not clear how long COVID lasts. It really varies for each person. Some people will fully recover in just a few months. Others may continue suffering the symptoms of long COVID, even if their infection took place over 12 months ago. People commonly report experiencing different combinations of the following symptoms when it comes to long COVID: sleep problems, fever, joint or muscle pain, headache, chest or stomach pain, changes in smell or taste, difficulty thinking or concentrating, sometimes known as or referred as brain fog, tiredness or fatigue, difficulty breathing or shortness of breath. Unfortunately, the list is not exhaustive. Next slide, please. So the question is long COVID a disability under the Americans with Disabilities Act? Yes, the short answer is yes. Long COVID can be a disability under the ADA. Really, almost any physical or mental impairment that can substantially limit a major life activity will qualify as a disability under the ADA. So if you have a medical issue that affects either your physical body or your mind, it most likely would be eligible for ADA protections, so long as it substantially limits a major life activity. And I will address the more in-depth definition of a disability under the ADA in a later slide. Next slide, please, Mary. So on July 26th of this year, in light of the rise of long COVID as a significant health issue, the Department of Health and Human Services and the Civil Rights Department of the Department of Justice joined together to provide a joint guidance. This guidance contains an enormous amount of information regarding long COVID. The guidance explains that COVID can be a disability, long COVID can be a disability under Titles 1 and Titles 2 of the Americans with Disabilities Act and Section 504 of the Rehabilitations Act of 1973. Each of these federal laws protect people with disabilities from discrimination. Notably, the joint guidance really just focuses on long COVID. It did not address when COVID-19 may meet the legal definition of a disability. But ultimately, we have to determine whether we're dealing with COVID-19 or whether we're dealing with specifically long COVID-19. We still have to go through the same analysis of whether the condition at issue is a disability. Next slide, please. So the joint guidance states that while long COVID can be a disability, it is not always a disability. We really need to conduct an individualized assessment to determine whether a person's long COVID condition or any of its symptoms substantially limits a major life activity. The joint guidance, which I thought was really fascinating, provided examples under Titles 2 and 3 of the ADA of ways businesses or state or local governments will need to make changes to the way they operate to accommodate a person's long COVID-related limitations. There were quite a few examples. I will just give you a few. For example, providing additional time on a test for a student who has difficulty concentrating, or modifying a policy to allow a person who experiences dizziness when standing to be accompanied by their service animal that is trained to stabilize them. After the seminar, I'd be happy to provide you with the link to the joint guidance because I do think it provides a vast amount of information for us. The guidance does not address examples of reasonable accommodation or non-discrimination in employment under Title I of the ADA, but notably, the guidance does footnote that any employment issues related to COVID-19 are discussed in the technical assistance issued by the EEOC, which was just updated on October 25th. And again, we can provide you to the link of the EEOC's technical assistance after our webinar. Next slide, please. Interestingly, I did want to mention that on the EEOC's website, on September 9th of this year, the EEOC did issue a notice recognizing that long COVID may be a disability under the ADA in certain circumstances and agreed with the analysis in the joint guidance. Next slide, please, Mary. So we briefly touched upon the definition of a disability earlier, but more specifically, the ADA defines a person with a disability as an individual with a physical or mental impairment that substantially limits one or more of the major life activities of such individual, a person with a record of such an impairment, or a person who is regarded as having such an impairment. Thus, a person with long COVID has a disability if it meets the definition of a disability as just described. Next slide, please, Mary. So what is a physical impairment? A physical impairment includes any physiological disorder or condition affecting one or more body systems. In the guidance, it provides us with a few examples of what some people with long COVID experience. Those examples were lung damage, heart damage, including inflammation of the heart muscle, kidney damage, neurological damage, and damage to the circulatory system. It also indicates that a mental impairment includes any mental or psychological disorder, such as an emotional or mental illness. Next slide, please. What is a major activity? Well, that includes a wide range of activities, such as caring for oneself, performing manual tasks, concentrating, reading, thinking, writing, communicating, speaking, breathing. It's a very long list. The guidance notes that an impairment does not need to prevent or significantly or severely restrict the individual from performing a major life activity in order to be considered substantially limiting. It did note that impairments that only last for a short period of time are typically not covered, although they may be covered if sufficiently severe. Next slide, please. The joint guidance, again, provides specific examples of how long COVID might substantially limit a major life activity. And I'll review just a couple of those examples. One example that the joint guidance provides is a person with long COVID who has lung damage that causes shortness of breath and fatigue, or another, a person with long COVID who experiences memory lapses and brain fog is substantially limited in brain function, concentrating, and/or thinking. Next slide, please. I did want to touch upon just a few cases which address how courts are treating major life activities in the context of the ADA. The first case is Norman versus Langone Health Systems out of the Southern District of New York. And it was ruled upon in 2020. And while it's not specifically long COVID related, the analysis by the court can still be applied to long COVID conditions. And in this case, defendant had a policy mandating that all employees receive the flu vaccine, and those employees seeking an exemption had to submit a request form. Plaintiff characterized her disability as an allergy to the flu vaccine. She had 2 instances of this allergy to the flu vaccine, or negative reaction, that is. One she named was during childhood, and another time was in 2001, where she was vaccinated in nursing school and suffered an adverse reaction. She submitted an exemption request form by her doctor indicating that she had a previous reaction to the flu vaccine, and eventually she submitted to the flu vaccine to avoid being terminated from her employment. The plaintiff then brought an action alleging that her employer failed to accommodate her. She alleged disability discrimination as well. The court held that even assuming plaintiff's allergy to the flu vaccine constitutes an impairment that limits the major life activity of breathing, she had failed to show that this impairment substantially limited her breathing at the time she sought an accommodation. The court did note, however, and agreed that impairments that are either episodic or in remission can constitute a disability within the meaning of the Americans with Disabilities Act. Next slide, please, Mary. This case I found interesting. It was recently ruled upon in September of 2021, and it actually is specific to long COVID, and the court does cite the joint guidance which we discussed today. So this is the Matthias versus Terrapin House case, which is out of the Eastern District of Pennsylvania. And in this case, plaintiff alleged claims of disability discrimination, that her employer regarded her as having a disability, and that disability being COVID-19, and her employer believed that her disability, that disability substantially limited or impaired a major life activity. On the date that plaintiff informed her employer that she needed to take leave, disclosing that she received a positive COVID-19 test, disclosing that she was suffering from loss of smell and taste, her employer decided to terminate her employment, stating that she just wasn't a good fit. Okay, well, the employer argued that a mere diagnosis of COVID-19 did not substantially limit one or more major life activities, and therefore it did not qualify as a disability under the ADA. As I'm sure you're not surprised, the court rejected the employer's argument. It found that COVID-19 does not qualify as a that COVID-19 does qualify as a disability, at least in some circumstances. It actually relied on the joint guidance, which came out in July of 2021. And it explained that, quote, some people infected with COVID continue to experience symptoms that can last months after being infected or may have new or recurring symptoms at a later time. The court did emphasize that an individual assessment is necessary to determine whether a person's long COVID condition or any of its symptoms substantially limits a major life activity in particular cases. This is an excellent segue into Alex's discussion of interactive process, reasonable accommodation, and undue hardship, and I will turn it over to Alex.
Thanks, Antoinette. So once you've decided that the particular employee that you're dealing with has a disability under the ADA, and you've made an assessment of their limitations as to their major life activities, you can then engage in the interactive process, which is the next step towards providing a reasonable accommodation. The interactive process is an informal discussion that you have to have with the employee to try and understand the scope of the employee's limitations, as well as the potential universe of ways that you can accommodate them. It's important to note that this obligation falls on both you as the employer as well as the employee. So that's why if an employee fails to submit medical documentation to support their request, or if you ask them to fill out an accommodation form and they fail to turn it in, then you can't be held liable for a failure to accommodate, because in that instance, the employee has caused a breakdown in the interactive process. And this interactive process is really a place where a lot of employers get tripped up, because it's more about the form and the process than it is about the result and the substance, as we'll see on the next slide with the Ruggiero case. This is a case out of the Third Circuit Court of Appeals in 2018. In this case, the plaintiff employee was a registered nurse at a hospital. She suffered from severe anxiety and esophagitis. The hospital that she worked at required all of its employees to get a Tdap vaccine, but this registered nurse refused to get the vaccine. She submitted a doctor's note that said that after she read the potential side effects of the Tdap vaccine, it triggered her anxiety, and she became terrified that she would get one of these potential side effects. So instead of getting the vaccine, she suggested to the hospital that she could just wear a mask all of the time while she was working. The hospital said, nope, that's not going to work. You're fired for not following the vaccine mandate. She filed a suit under the ADA, and the trial court dismissed the case. But on appeal, the Third Circuit reversed and found in favor of the employee. And the Third Circuit held that there was a plausible inference that the hospital failed to engage in the interactive process. Basically, she suggested an accommodation, either excuse me from the vaccine requirement or let me wear a mask. And the hospital, instead of having that required back and forth, just said no. You have to engage in an interactive process. There has to be some form of a back and forth informal discussion. Otherwise, you're going to run afoul of the ADA. So regardless of what the accommodation request looks like, you have to engage in the interactive process. Next slide, please. And once you've engaged in that process, then you're in a position to ascertain whether the requested accommodation is reasonable or not. And specifically, when we're talking about employees who have long COVID, there's a number of potentially reasonable accommodations that we would expect to see requested. Things such as a leave of absence, depending on the length of time, could theoretically be reasonable. Perhaps a reduced work schedule. Maybe it's an employee who was hospitalized, has been discharged from the hospital and is regaining their strength, but still has some of the symptoms of long COVID. And maybe they can only work 2 or 3 days a week, or maybe they can only work 4 hours, but every day of the week. So perhaps some sort of alternate schedule. Potentially job restructuring could be a reasonable accommodation by removing non-essential duties from that employee and giving them to another employee. Potentially reassigning the employee to a different, less strenuous position if you have an opening for them. Or as we've all gotten used to in the COVID era, potentially a remote work arrangement could be a reasonable accommodation depending on the specifics of that employee's position. With that said, there are a number of things that you never need to do. You don't ever need to remove essential job functions as an accommodation. And the best way to know whether a job function is essential is to look at the job description. And that's a very good reason that you should always keep your job descriptions up to date and make sure that they accurately reflect the true essential functions of that job. So that way, if you're ever defending a claim of failure to accommodate and you want to say, no, we can't remove that job function, it's essential, you can just point directly to the job description and say, look, it's the first bullet point on your job description. We're sorry, but we can't remove that function. As you're considering accommodations, you never need to lower your performance or production standards, and you never need to provide accommodations that create undue hardships on you as the company. And that could be administratively, that could be a scheduling hardship, or it could be a financial hardship. Likewise, you never need to provide the employee's preferred accommodation. The law just says that you have to provide a reasonable accommodation. It doesn't necessarily need to be the one that the employee demands. And again, this is a really good reason to engage in the interactive process in good faith, because if you fully understand what the employee's limitations are, you're going to be in a better position to potentially suggest alternative accommodations that work better for you as a company. Next slide, please. So although we're talking about the ADA today, you should also keep in mind that someone with long COVID could potentially have rights under the Family and Medical Leave Act as well. And we're not going to get too deep into the weeds on this, but I just want to put it on your radar that you may have obligations under the FMLA. The ADA and the FMLA both generally deal with health issues, but they define those health issues very differently. As Antoinette said, a disability under the ADA has to do with a substantial impairment of a major life activity. Conversely, the FMLA deals with serious health conditions, which generally speaking are issues that require ongoing treatment or inpatient care. And the federal regulations say specifically, the ADA's disability and FMLA's serious health condition are different concepts and must be analyzed separately. So if you have an employee who is suffering from long COVID or requests an accommodation as a result of COVID or long COVID, you should immediately be thinking about performing a separate analysis under the FMLA as well. Next slide, please. So now that we've taken a high-level view of the ADA and how it applies to long COVID, there are a number of steps that you can preemptively take to minimize any type of legal claim. And the first thing is to go ahead and analyze the accommodations that we would expect to receive from sufferers of long COVID. We think those are going to be things like alternate scheduling arrangements, remote work, transferring job duties, things like that. You can go ahead and gather the data that you would need now to make the assessment as to whether that's going to be reasonable for your company or whether it would be an undue hardship. Make sure that your ADA accommodation process is up to date and that employees know about it. It should be in your employee handbook and clearly spelled out. You don't want to be in a situation where an employee needs an accommodation, but they don't know how to request it, or they go to the wrong person to request it. You should make sure that your medical forms are up to date so that if an employee requests an accommodation, you can give them a form to fill out. And that's a great way to kick off the interactive process because it gives you some background information before you even step into that meeting with the employee. And then lastly, make sure that your managers and supervisors are trained on the importance of all of this and make sure that they are funneling the requests to the proper people, whether that's HR or whether it's a leadership team. You want to make sure the proper people are dealing with these accommodation requests, and you want to make sure that your managers and supervisors know that there are limitations on the types of questions that they can ask and that it's a sensitive topic. Next slide, please. So since COVID has been around for about 18 months, 2 years now, we're starting to see some cases of long COVID trickle into the court system. So we're going to go over a couple. The first one is this Edelman case, which was filed in the Eastern District of New York in June of this year. In this case, a general contractor worked for a health company. He contracted COVID-19 and was admitted to the hospital for 2 weeks. His employer texted him while he was in the hospital that he was being temporarily laid off. He was eventually discharged from the hospital, but continued to suffer from what he alleged were long-haul symptoms for weeks after his discharge. And his employer told him that they weren't going to bring him back. He filed a lawsuit under the ADA, claiming that the employer failed to engage in the interactive process and fired him as a result of his medical condition. And the lawsuit specifically alleges no employees engaged in any form of interactive process or cooperative dialogue to discuss possible accommodations that might have allowed Edelman to return to work then or in the future. So again, this really highlights the importance of the interactive process. This employee here had two claims. One was for discriminatory discharge and the other was for failure to accommodate. And the employer really would have had a great defense to the failure to accommodate portion if it had engaged in the interactive process and documented that. Interestingly, as we'll see on the next page here, the employer in this case filed a motion to dismiss somewhat recently, claiming that in May of 2020, when the employee contracted COVID, no one in the world understood COVID-19 to be anything more than a transitory, albeit serious illness, so no reasonable accommodation was required. So essentially, the employer argued, this isn't a disability, so we don't need to accommodate. That motion was granted in part and denied in part. Unfortunately, the docket entry in that case doesn't contain a written opinion by the judge, so we don't know exactly what part was granted and what part was denied. Personally, I don't think the argument written here is a meritorious one, as Antoinette discussed earlier. When you're determining whether an employee is disabled under the ADA, it needs to be an individualized assessment of that employee's limitations. You can't really make a broad assessment that this disease is never a disability because it's always a transitory illness. It really needs to be an individualized assessment of the employee's limitations. In the next case, on the next slide, we're going to talk about the Hamada case. This is a California state case that was filed in March of 2021. In this case, the plaintiff worked as a lab technician at a hospital. She contracted COVID in April of 2020 and was put on medical leave for 6 weeks. She was returned to work after several weeks, but still continued to suffer from symptoms of long COVID. So she asked around at her place of work about potentially getting on intermittent leave to accommodate her. But her HR department supposedly told her, you better not, in reference to asking about intermittent leave. So she didn't ask for protected leave. She didn't ask for her accommodation, but she did have intermittent absences as a result of her long COVID symptoms. And those absences were treated under the company's attendance policy. So she was ultimately terminated as a result of her attendance. We think this will be the prototypical long COVID case. It's an employee who's hospitalized, has severe symptoms, but then is on the mend, has been discharged, can work in some form or fashion, but just needs an accommodation in order to fully get back to strength. This case actually settled, so we don't know how it would have ended up. Next slide, please. So just to wrap things up, a couple key takeaways. Keep an eye out for the EEO's technical assistance that should be released soon. That will give us more details on how they're treating long COVID. As discussed, they've already said that long COVID and COVID in general can be a disability depending on the individual's particular circumstances, but we expect to have more details in the technical assistance. And keep in mind that anytime you're dealing with an accommodation request, whether it's COVID, long COVID, or any type of accommodation request, really, the first thing you should be thinking about is how can I engage in the interactive process and how can I document that I've engaged in the interactive process? Because that's going to be your best defense against claims under the ADA. And with that, Dina, I'll kick it back to you.
Thank you, Alex and Antoinette. These are really such interesting and hard issues that employers have to face. And I think we're all doing, the best job we can to deal with them. And, we're managing these cases that are coming out all the time. So thank you for that excellent summary of the new case law that's been coming out. Our next topic is diversity, equity, and inclusion. And we have Angela and Steve coming back to give us this next presentation. So Angela and Steve, take it away.
Great, thanks, Tina. Excuse me, and good morning, everyone. Many of us know that diversity, equity, and inclusion, or DEI initiatives, have been a part of the makeup of corporate structure for many years now. However, over the past year, we've seen an increased interest in moving these initiatives to the forefront, and that's across various industries, geographic regions, and business sizes. That's driven in some ways by the pandemic and its impact on disenfranchised communities, and driven in other ways by civil unrest in our country and what many have called a racial reckoning. Either way, this increased interest in DEI has led to organizations creating or revamping their DEI initiatives, although a lot of that has taken place while a significant portion of the workforce was working remotely. Well, now that many of us are heading back to the office or soon will be, it's a great time for organizations to take a deeper look at what our DEI programs should look like and the fundamental components that effective DEI initiatives should have. And that's what we'll be talking about today. We are dividing this discussion into 4 parts. First, what is DEI and why does it matter? Second and third, recruiting and retention, since we tend to think about DEI initiatives in these 2 constructs. And lastly, we'll talk about the impact of the pandemic and how the events of the last year and a half have impacted diverse populations and how a company can take that into account in shaping its DEI initiatives. Next slide, please. So first, let's start by level setting and making sure that we understand these terms: diversity, equity, and inclusion. So diversity is all the ways in which people differ, or the range of human differences. Years ago, we used to think of diversity as just race and gender, but we know it's much more than that. It's race and ethnicity, gender and gender identity, also sexual orientation, also age, social class, physical ability or attributes, religious or ethical value systems, national origin, political beliefs, and potentially many other categories. But essentially, diversity reflects individuals and groups from a broad spectrum of different and different philosophical ideals. So if diversity is the bringing together of people having different demographics and ideals, then equity is the process of ensuring that a company's operations and programs are impartial and fair, and that they provide equal possible outcomes for every employee, regardless of those different demographics and ideals. And while equity relates to fairness in different processes, inclusion describes the workplace environment and culture. In other words, an inclusive workplace promotes a sense of belonging. It values practices and respect for employees' backgrounds and beliefs, and it protects diversity by valuing individuals and groups and creating an environment that's free from prejudice and where mutual respect is just a part of how the company operates. And this becomes key when we talk about retention, because employees often will not stay where they don't feel included or a part of the team. You may have heard the expression bringing your whole self to work. Well, inclusive workplaces create environments where everyone feels the freedom to do that. So now that we know what DEI means, let's talk about why effective DEI initiatives are important, other than it being the right thing or good thing to do. There are multiple rationales, and I'm going to go in an order that's a little different than what you see on your slide here. First, the business rationale, which is basically that DEI initiatives help companies make more money. That is because diverse workforces are more productive and more creative. And we have statistics that show this to be true. Companies with diverse management teams have 19% higher revenues. 85% of CEOs say that having a diverse workforce improve their bottom lines. And with regard to recruitment, 67% of job seekers say that diversity is an important factor when considering a company. Next, leadership rationale is that leaders who are culturally sensitive tend to have communication skills, interpersonal skills, and social networks that lead to them attaining high levels of position, not just within their industries, but outside of their industries as well. The democracy rationale is the idea that a diverse workforce that reflects the communities that it serves is better positioned to foster trust in that company as a service provider to that community. And relatedly, the demographic rationale is that as our communities become more diverse, so should the industries that service them mirror the communities that they represent. And we know that based on the 2016 and 2020 census data, projections are that by 2050, more than half of the US population will be from visible minority communities. Now, the last rationale, the risk management rationale, is probably what resonates the most with those of us who are concerned with legal exposure. This rationale is that effective DEI initiatives help organizations reduce potential liability exposure and litigation expense, meaning that equitable and inclusive workplace cultures discourage harassment and discrimination by helping to ensure that salary and other employment decisions are based on business factors rather than on those demographic factors that we talked about. Now, as a result, these diverse and equitable workplace cultures decrease the likelihood of discrimination complaints and litigation. Now, that being said, of course, even the best DEI program cannot guarantee 100% elimination of discrimination complaints. Nevertheless, workplaces that actively promote equity and inclusivity are more likely to have processes in place that reduce the kinds of biases in employment decisions that often lead to discrimination complaints and lawsuits. And let's talk about a couple of examples of what that might look like. Now, imagine you are a working parent in 2020, and because of the pandemic, you're forced to work from home alongside, let's say, your 4-year-old child. You're in a virtual meeting on camera, and somehow your 4-year-old enters the room and does what 4-year-olds tend to do, which is make their presence known clearly and loudly. Now, rather than laughing it off or showing some grace and patience, your boss on the other end of this virtual meeting says, "Hey, you really need to take care of your kid's situation." Now, this happens multiple times until several weeks later, you're terminated. Or imagine that before your termination, you ask your employer to adjust your work schedule so that you can better take care of your child who's home from school. And not only does your boss tell you no, but they tell you that if you try to take leave under the FFCRA or the Families First Coronavirus Response Act, they will demote you or terminate you. Well, that doesn't sound like an inclusive workplace environment, right? Well, those are the allegations of 2 cases, Delaney versus Advantage Sales and Wallace versus Hub International Insurance Services. Both cases were filed last year in Pennsylvania and California, respectively. Now, whether the allegations are true and whether they constitute violations of anti-discrimination laws still remains to be proven in court. But these are still 2 examples of how adverse employment action was allegedly threatened or actually carried out based on non-performance or non-merit related reasons. These types of circumstances are less likely to happen in a workplace that, 1, has processes in place to guard against biases and discrimination in employment decisions, and 2, has a workplace culture that promotes inclusivity and belonging, even for working parents. And we'll talk later about strategies for working parent support. Next slide, please. If the threat of litigation isn't enough, we have a recent example of successful litigation in favor of a plaintiff with the Diaz versus Tesla verdict handed down on October 4th this year, so just a few weeks ago. This was a federal jury in San Francisco that ordered Tesla to pay nearly $137 million to a former worker because of racist treatment. The plaintiff was a Black elevator operator who accused Tesla of ignoring racial abuse that he faced while working at the company's factory. Some of the allegations included the N-word and other racial slurs being used repeatedly, swastikas and other derogatory images being painted on bathroom stalls. So this was a hostile environment and legally speaking and generally speaking, a non-inclusive workplace culture. Now, what's notable here is, 1, that this was a federal jury, not a state, despite the fact that we tend to think of federal law and federal juries as slightly more favorable to defendants. Number 2, the plaintiff here was a subcontractor, not a Tesla employee. The jury rejected Tesla's argument that staffing agencies that it contracted with were responsible for training the subcontractors on harassment policies. Instead, the jury found that Tesla was responsible for investigating and eliminating the discriminatory treatment once it was brought to their attention, and they failed to do so. The jury found that Tesla was the plaintiff's joint employer with the subcontractor, that Tesla failed to take reasonable steps necessary to prevent the harassment, and that the plaintiff was harmed as a result of Tesla's negligence. Now, this is, of course, one of the more extreme examples that we have, since the discrimination here was so blatant and overt. But the point remains that more diverse, equitable, and inclusive workplaces are better equipped to prevent this kind of behavior from occurring in the first place, or at least effectively addressing it when it comes to light, and avoid high cost dollar exposure and very bad publicity for the company. Next slide. And I'm going to turn this over now to Steve to talk about anti-discrimination laws.
Yeah, sure. Thank you, Angela. So really, effective DEI programming starts with establishing an equal employment opportunity policy that reflects the current state of the law, and then obviously complying with that policy. So just some notes on some applicable laws that prohibit discrimination. We're all familiar with Title VII, which prohibits discrimination based on race, color, religion, sex, national origin, and pregnancy. Also, sexual orientation and gender identity. There's the Age Discrimination in Employment Act, which prohibits discrimination based on being age 40 or over. There are also jurisdictions, states that have passed laws that prohibit reverse age discrimination. So prohibiting discrimination on being 40 or over, or 40 and under. Additionally, there's the Americans with Disabilities Act, which prohibits discrimination against individuals with disabilities and requires reasonable accommodations, as Alex and Antoinette discussed in their last presentation. If we could go to the next slide, please. There's the Equal Pay Act of 1963, which protects men and women who perform substantially equal work in the same establishment from sex-based wage discrimination. There's GINA, Title II of the Genetic Information Non-Discrimination Act of 2008, which prohibits employment discrimination based on genetic information about an applicant, employee, or former employee. And then there's also state and local laws, which may add other protected classifications. For example, in my home state of Minnesota, membership on a local commission is a protected classification. So lots of room for variation there as well. So, these laws also generally prohibit retaliation. And given this, extensive patchwork of law at the federal, state, and sometimes local level, it might beg the question of why is effective why is an effective DEI initiative really important or necessary? And the answer to that's really twofold. First of all, effective DEI programming supports an equal employment opportunity policy and helps ensure that employers comply with that. And second of all, DEI goes beyond legally protected classes and creates and promotes a workplace that's inclusive and welcoming for all. All right, next slide, please. So we want to talk a little bit about recruiting, and diversity recruiting is the practice of hiring candidates using a process that's free from any kind of bias for or against an individual or group of individuals. It's still merit-based recruiting, still aims to find the best possible candidate, but it's structured to give all applicants, regardless of background, an equal opportunity. And it's important to be strategic about recruiting, particularly because there are more job openings than people looking for work, and companies are facing the tightest labor market that they have in really 50 years. So when recruiting, there's some things we want to do to avoid running afoul of the laws. We want to avoid questions relating to classes that are protected by discrimination laws. And there's lots of different questions that should be avoided. Questions relating to whether the candidate has or intends to have children, marital status, race, religion, sexual orientation, age, disability, citizenship, or drug or alcohol use. Sometimes even seemingly benign and broad questions can be viewed by candidates or others as problematic because they may elicit the type of information that otherwise you shouldn't be asking about. For example, what do you do in your free time? may be viewed as eliciting information relating to whether the candidate has children or their marital status. So something to keep in mind. You want to stray away from questions that seek to elicit that kind of information. This also applies with regard to job postings and applications. You want to be careful with the way that your job postings are worded. For example, a job posting that seeks, young applicants or applicants with, just a year or two in the field, or advertisements containing references such as energetic or fresh-faced may be viewed as, symptomatic of age discrimination. Comparably, advertisements that contain gendered and gendered terminology like busboy or waitress or stewardess may be viewed as running afoul of gender discrimination laws. Advertisements seeking able-bodied applicants or saying that the applicant must be in good health may be problematic from a disability law perspective. Same thing with advertisements seeking American-born or English-speaking candidates that may be problematic from a national origin perspective. And, another thing that is also something that you should generally stray away from in terms of posting, for jobs is basically saying that clean records only or criminal records, need not apply, felons need not apply. That has the potential to run afoul of a lot of, workplace opportunity laws that are popping up, relatively quickly in a lot of jurisdictions throughout the company. For example, New York City just passed one this past July. Okay, if we could go to the next slide, please. So another thing about recruiting that I should just really briefly mention with regard to the ADA is that the Americans with Disabilities Act does require reasonable accommodations in the recruiting process. So if an applicant has, an issue with regard to sight or dexterity or hearing or what have you, there, is an obligation to provide an accommodation in that context to really work with that applicant to make sure that they are able to get a fair interview process and they're able to complete that as successfully as possible. With regard to recruiting, there's some common biases in the interview process that we should be aware of and that we should really seek to temper. One is the confirmation bias, and that's seeking information to support the interviewer's initial assumption about a candidate. This is a surprising statistic, but 60% of interviewers will make a decision about a candidate within the first 15 minutes of meeting them, and some will have done it before the interview even happens. If the questions being asked are irrelevant and trying to elicit answers that solely seek to support an initial assumption about that candidate, there's an obvious danger that we could be passing over great candidates for really no good reason at all. Another bias in the interview process to avoid is affect heuristics, which is judging a candidate's suitability for a position based on irrelevant and superficial factors. Quite simply, if you are judging somebody's suitability for a position on the basis of noticeable tattoos or weight, obviously you're overlooking, other attributes that might make that person a really great candidate for the job. So another bias to avoid in the interview process. Similarly, the halo effect should be avoided. That's relying too heavily on one particular positive aspect of the candidate to the, essentially to the exclusion of other information regarding that candidate. For example, where the person went to school. That should be avoided. You really want to take into account the candidate as a whole, not focus too heavily on one particular aspect. And the similarity attraction bias is hiring candidates who are like us or have similar traits. Obviously, if those don't correlate to job performance, they shouldn't necessarily be a part of the calculus. So another thing to avoid in the hiring process. If we could go to the next slide, please, Mary. Some tips for recruiting is that requiring implicit bias training for recruiters, interviewers, and other hiring personnel can help weed out the detrimental effects of those particular biases. So that's recommended. Resume only decisions should be avoided to the extent possible so that employers can get, kind of a more holistic view of a candidate. You should utilize a candidate evaluation form that helps generate analytics so that you can, kind of compare candidates more broadly using those same kinds of analytics. Utilizing group deliberation and decision making too is always a good thing. Generally more heads are better than one when it comes down to hiring decisions. And re-examining your outward facing branding. You want to be careful about the way that the company is portrayed when it comes to the website, brand messaging, pictures on Glassdoor, what have you. Think about what kind of an impression you're making on potential candidates. When actively sourcing, you should think about the messaging that's being placed on job boards. You certainly want to include a statement that indicates that you're an equal opportunity employer. And you also might want to think about where you're posting for positions. For example, Greenhouse senior recruiter Ariana Moon has said that we need to diversify where we're posting job listings. We saw a huge impact on our pipeline once we began listing jobs on diversity recruiting websites. So think about your outward facing messaging as well. Regardless, at every point during the interview process, the candidate should feel that they're applying for a position and for an employer where they can really thrive, and should feel that they're being respected and treated well throughout the process. Next slide, please. And with this, I'll hand it over to Angela.
Thanks, Steve. And before I talk about retention, I just want to answer a question that was posted in the Q&A. What if a job posting describes a top tier school candidate? Is there any concern from a DEI perspective? And Steve touched on this a little bit in talking about whether or not to mention or ask in an interview what school a candidate attended. As far as seeking top tier school candidates, that type of policy or requirement may not be discriminatory on its face, but you want to think about the potential discriminatory impact because certain schools tend to have very low diverse populations. And you also want to think about how does that play out in the interview and the candidate selection process. You want to think about being a little bit more specific in the criteria that you're looking for and the reasons why you're seeking a top tier school candidate. Perhaps those reasons can be accomplished, or those objectives can be accomplished in another way. So moving on to retention, now that our effective recruiting efforts were successful and got our diverse employees in the door, how do companies get them to stay? This starts with the onboarding process. And the results of a recent HR survey are really quite telling. The survey reports that 31% of people have left a job within the first 6 months, with 68% reporting that they may have departed or have departed a job within the first 3 months. So how an employee is engrafted into a company matters a great deal. And when we talk about onboarding, we're specifically talking about training, opportunities, and introductions. With training, it's how new employees are receive instruction over and above the base level qualifications and requirements for the job. Are they provided with adequate instruction for how to perform in order to meet the organization's expectations? With regard to opportunities, what's the basis for decisions about what opportunities and assignments are offered to employees, especially for high profile opportunities that will advance their position within the company? And with regard to introductions, to what extent are new employees introduced to key persons within the organization that have decision-making authority regarding their advancement? New employees will take stock of these factors very quickly, and within the first 3 to 6 months of starting at a company, will use these factors to make a decision about whether to leave or to stay. And what we want you to think about here are those implicit biases that Steve mentioned, which might impact onboarding decisions. Unconscious biases not only have significant impact on feelings of inclusiveness, but they can also potentially create institutional barriers to growth over time. So it's important that the employees start off on the right foot as soon as that they are hired. Next slide, please. So beyond the onboarding process, here are a few more factors to consider with regard to retention. We've already addressed the unconscious biases, supporting the creation of resource groups. And this includes minority, women, LGBTQ, or others. Resource groups create opportunities for diverse employees to interact with one another and create a support system for members of the group to flourish and learn from one another. Promoting mentor and sponsor relationships. We want to distinguish between these two things. Mentors are actively engaged with the employee and helping their growth and development over time. Sponsors are actively engaged with advocating for the employee with key persons in the organization and connecting the employee to key persons. Both mentors and sponsors are essential to all employees' growth and development. So the key here is to ensure that diverse employees have the same access to those relationships as everyone else. Make the path to growth transparent. Make sure that everyone knows what opportunities are available and what competencies are needed to get to the next level. Additionally, you want to assess whether there are unwritten rules of advancement within the company. Diverse employees who are excluded, whether intentionally or unconsciously, from certain social networks within a company are most often the employees who will be unaware of those unwritten rules. Courageous conversations. So when conversations or actions negatively impact someone or a group of people, that behavior should be identified and called out as soon as possible, whether in a subtle way or overtly. One example might be if a team member's contribution is dismissed or overlooked, and then someone in the dominant group restates the same idea and takes credit for it. This is a great opportunity for someone to say, to remind the group where the idea originated. And this is true also if a statement is made that's potentially offensive toward a particular person or group. If the conduct in question rises to the level of a possible discrimination or harassment report, that should be investigated. And we'll talk in a moment about what that investigation should look like. With regard to managers, you want to make sure that they're trained on how to lead diverse teams, specifically how their behavior impacts their team members' sense of belonging, and by way of example, teaches their team members what behavior is and is not acceptable. Managers should also be encouraged to continuously assess their processes to ensure that everyone on the team gets the same opportunities. And that should be based on objective as criteria as possible. Another way to motivate managers to become more inclusive is by rewarding them for retaining new talent on their teams. And obviously those rewards can take many different forms. And it's great to be creative about what that might look like. Stay interviews, I think, are really an underutilized resource, and research shows that it can be one of the most effective diversity retention tools. This is a proactive way to make sure that your diverse talent understands and appreciates their value in the company before they even begin to think about transitioning. And so it's important to identify who those possible transitioners might be and have those conversations sooner rather than later. Next slide. So in a perfectly diverse and equitable and inclusive world, all of the tools that we've just discussed would be implemented and there would never be a complaint or allegation of discrimination. And we know that that perfect world doesn't exist. There is always the potential for a complaint or report of discrimination or harassment. What matters, however, is how those reports and complaints are handled and that they are investigated effectively and thoroughly, because the handling of the complaint can really make a difference in building trust with the reporting employee. So the first thing that you want to do is establish a clearly defined reporting process. This should answer the question of what kind of conduct constitutes discrimination or conduct that violates the company's EEO policy, and the question of who should receive reports of possible discrimination. All of this should be clearly stated in the company's employee handbook or manual, a copy of that provided to all employees at the point of onboarding, and the policy should be continuously reviewed and revised to reflect changes and updates in the law and in the company's own processes. You also want to conduct a thorough internal investigation or retain outside counsel. Now, whether or not to conduct the investigation internally or retain counsel is, of course, a case-by-case decision that counsel can also help make the determination. There's always the potential for litigation, and so involving counsel can help protect privilege over certain communications and documents related to the investigation. Retaining counsel can also help reinforce that the company is taking the complaint seriously and is taking an objective look at the allegations, especially if the complaint involves allegations of egregious conduct or a high-level employee. And whether the investigation is conducted internally or by counsel, there are certain boxes you want to check, including interviewing key persons, not just thoroughly and efficiently, but also in a way that fosters trust in the process and encourages the complainant and witnesses to be forthcoming and honest with the investigator. You want to collect as many documents as possible and make sure that they are preserved in a way that makes them accessible should more complaints arise later on. And there are a few lessons we learned here from the recent Tesla verdict. The plaintiff's allegations were not just that the discriminatory conduct occurred, but also that once it was reported, the company failed to thoroughly conduct an investigation. And so you want to make sure that, again, despite complaints arising, that you investigate them as quickly and as thoroughly as possible. I know we're at time here. Should we go on to the next section, which is our last section, and quickly wrap up?
Sure.
Sure. So I'll talk just very briefly about the pandemic impact. It's obviously affected how everybody sees the world and how employees are seeing their job places as well, or the workplaces. Can we go to the next slide, please? So there has been, I'll just summarize this. Generally speaking, members of diverse populations have reported additional challenges and felt them more acutely than non-diverse counterparts over the course of the pandemic. Let's go to the next slide, please. And this is manifested itself, in substantial loss of, numbers of women from the workforce, actually, over the course of our recent history. 275,000 women left the workforce in January of this year. And other studies show that more than 2 million left the labor force in 2020. And that's partly attributable to a disproportionate number of basically, or partially attributable to the pressure and stress of working from home while children are also attending school from home. If we could go to the next slide, please. So some considerations to think about to help alleviate these issues, is potential relaxed work schedule, more flexible hours, resource and support groups for everybody, creating spaces that are, good for sharing and for listening, over communicating with employees with regard to plans, educating them. 50% of people don't know what meaningful action is being taken by their employers to increase inclusivity. So really driving that home with employees is important. And then also normalizing the new normal with regard to children or pets in the home workspace when remote work is, the venue for a particular employee. And with that, I'll turn it back over to Angela.
Thanks, Steve. And just the last section here, we just wanted to acknowledge and discuss how the racial reckoning, so-called racial reckoning that the country has experienced over the past year has is a part of what has motivated companies to revisit their DEI policies and programs. And we wanted to just offer a few suggestions on how to effectively put that into acknowledgement and incorporate it into your DEI initiatives. And we can go to the next slide and the next one. And so there are just several statistics that that support the contention of how these ideas and issues have impacted companies in a way by way of interviews, quotes, and the like. And we just want to offer a few words of instruction, and you can go to the next slide. So many companies have taken this opportunity to release public statements, put things on their website to voice support for racial equity, and that's great. But words and platitudes are simply not enough. You want to make sure that you take action and implement a lot of the policies and protocols that we've talked about. You want to ensure that ideas are implemented and maintain consistency over time. That means revisiting them to make sure that they are achieving the measures that you sought out for them to achieve. And continue prioritization and expanded budgets for DEI more broadly, just to, again, reinforce your company's commitment to improve DEI, which may come by way of, if you don't already have it in place, creating and maintaining a DEI committee or a chief diversity officer. In other words, creating committees or leaders who are specifically assigned to taking authority and ownership of these initiatives and ensuring that they are carried out effectively over time for the entire workforce. And I think that's it. Thank you very much.
Thank you, Angela and Steve. So we are moving now on to our last presentation of the day. It is the NLRB, re-energized and focused on non-union employees. We have Dan and Garrett to present on this final topic for us of the day, and I think they are ready to go. Dan and Garrett.
Yes, we are. Thanks, Dina. Good morning, everyone. It is still morning, and I know all of us in this webinar are feeling energized and focused, and that's really terrific. Perhaps a little less terrific for employers, and for those of us who represent employers, is that the NLRB is also feeling re-energized, and it's got its sights set on non-union employers, which is most of you. So that's correct. This is not the conventional union segment of the program where you non-union folks might tune out just a little bit. We're in the closing days of a month that people are calling Striketober because there's been so many strikes and so much labor unrest around the country. And yes, it's Striketober. That's a real thing. You can Google it. And all this energy and activity in the workplace matters for non-union employers. And for those of you, I know we have some public sector attendees who are not covered by the NLRA. Stay tuned, because a lot of the principles you'll hear here also apply under your state and local bargaining statutes. So before we dive in, I just want to give you a quick overview of what we're going to cover. I'm going to start with a short refresher on the NLRA and how it applies to non-union employees. Then I'll talk a little bit about the agency itself. Garrett will then talk about some of the areas where the NLRB is going to be active in the non-union space. And I'll round out that list of areas to watch for. Then I'll touch on some legislative developments, and we'll close with a couple of hot topic cases of interest relating to COVID and political activity in the workplace. Again, non-union employers and interacting with the NLRA. Okay, so here we go. Can we have the next slide? Oh, I'm sorry, can you go back? We're already on the next slide. Thank you. So quick refresher. The NLRA, it's been around for a long time, since 1935. It was enacted during the New Deal, and it is not a neutral piece of legislation. It was designed to protect employees who are pushing back against their abusive employers, and to rebalance the power dynamic between employer and employee by giving employees the right to engage in collective action. Next slide, please. So the core of the NLRA is Section 7. These are rights, Section 7 rights that apply to all non-supervisory employees, union or non-union. And Section 7 states that employees shall have the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection, and shall also have the right to refrain from any or all of such activities. So it's a mouthful, but all that text breaks down into 3 basic rights or categories of rights. 1, the right to organize or to refrain from doing so. 2, for those employees who have organized and formed a union, they have the right to bargain collectively. And 3, they have the right to engage in other protected concerted activity. So what does that mean? Well, concerted activity is activity engaged in, with, or on the authority of other employees, including activity intended to incite group action or speaking on behalf of other employees about terms and conditions of employment. Essentially, that means one or more employees banding together for the benefit of more than one employee. So you can even have one employee who is engaged in concerted activity if that activity is for the benefit of other coworkers. Next slide, please. So the key elements of the Act of the NLRA, we just covered the main one, Section 7, which covers, again, union and non-union employees. And the rest of these key elements are things most of us are familiar with. The Act established the NLRB and its general counsel. I'll talk about that in a couple minutes. It governs the representation election process, regulates the collective bargaining process where there is a union, and the Act has a list of unfair labor practices, ULPs, which are for both unions and employers, which are violations of the rights afforded by the Act. And one of those ULPs is interference with employees' Section 7 rights. So again, if an employer interferes with an employee's Section 7 rights, that's an unfair labor practice, whether or not that employee is represented by a union. Next slide, please. So the role of the NLRB, again, probably pretty familiar stuff. The NLRB oversees union elections, investigates ULP charges. It decides cases either at the administrative trial level by an ALJ, administrative law judge, or through appeals to the board itself. And the board issues binding precedential decisions. And the NLRB can also promulgate administrative regulations, which it has done more frequently in recent years. Next slide, please. So the board right now, this is the current board. Members of the board are nominated by the president and confirmed by the Senate. And a majority of the board right now are Democratic Party appointees. And what that means is that for the foreseeable future, the board has a majority that is going to take a decidedly expansive view of employee rights and union rights under the Act. Next slide, please. So the other key player under the NLRA is the General Counsel. And the NLRB GC is one of maybe 2 or 3 federal agency general counsel who is nominated by the president and confirmed by the Senate. And that's significant because it means the position is independent from the board itself and serves a 4-year term. The GC is responsible for investigating and prosecuting ULP cases, and she also oversees all of the regional offices of the NLRB around the country. All of the regional directors, they all report to the general counsel. The new current general counsel is Jennifer Abruzzo, who started her term in July. And she is a longtime NLRB staffer who rose up through the ranks to a very high level at the agency. She then left during the Trump administration. She went to work for the Communication Workers of America. It's a large national union, which might tell you where her sympathies lie. And then she came back at the request and nomination of President Biden. So why are we talking so much about the new GC? Well, as I noted, the GC is the prosecutor of NLRA violations. And that role gives the GC really a ton of influence over the way that the NLRA will be interpreted and applied. The GC sets the priorities of what types of cases the agency will pursue, what industries might be targeted, what legal theories will be advanced. And she does this by picking the cases that will be the priorities for her, the cases which provide an opportunity to reverse precedents that she doesn't agree with, or which present an opportunity to create new law that aligns with her view of the Act. Next slide, please. So in her first few months in office, Ms. Abruzzo has made it clear that she does intend to seek reversal of many if not all, of the board's employer-friendly decisions that were issued under the prior administration. She also has identified areas of the law that have not been in flux, that have been settled for many, many years, but which she appears interested in changing as well. And many of the areas that she has targeted, or she has identified that she's targeting, could have major implications, again, for non-union employers. Unionized employers are going to get rougher treatment at the NLRB. There's no question about that as well. But here we're focusing on the areas of the law that Ms. Abruzzo has identified as her targets that could have an impact on non-union employers and employees. And so now I'm going to hand it off to Garrett. He'll take us through some of those key areas and what we expect to see happen there.
Yeah, thanks, Dan. So we certainly expect to see the board make a number of broad and consequential changes that certainly fall into line with these planned changes that the general counsel has spelled out. And one of those expected changes is likely to come in the way that the board reviews workplace handbooks. So to understand where the board is likely to go, we need to look at where they've been. So let's look back briefly as far back as roughly 2012, when the board really began to sink its teeth into a lot of these workplace handbooks. This trend largely began by the board taking on cases, and in the course of investigating those cases, requesting to look at various policies and handbooks, regardless of whether it actually mattered for the charge that they had in front of them. They would review those under a pretty broad reading of prior case law and find additional violations of the National Labor Relations Act, really regardless of whether it, again, pertained to the charge that was in front of them. Now, predictably, this led to a number of cases being filed with the board for alleged violations of the act based on these policies, because the board utilized this broader standard. And that broader standard basically said that if the board decided that a policy could be reasonably construed to violate the act, then the policy could not stand. Now, critics of this broader standard largely said, look, this is entirely too broad. It doesn't take into consideration whether the policy has actually been used to violate the Section 7 rights of the employees, and it does not look to whether there's a legitimate justification for that policy on the books. So when the board changed political majorities in 2017 under the Trump board, this handbook review precedent was reversed in favor of what is currently in place, though likely not for long, which largely balances the policy's potential impact on Section 7 rights with a company's justification for utilizing the policy. Like I said, this standard is likely to be short-lived. Now that the board has gone back to pre-2017 political makeup, and in light of the general counsel's new memo detailing her plans, it's likely that the board will revert back to the reasonably construed standard, and again take aim at these workplace policies and they're without regard to their effect or to actually how they're used in the workplace, or whether there is any kind of justification, legitimate business justification for those policies. So I wanted to point out just a couple of ways that are likely to have broad impacts in the workforce overall, regardless of union representation. If we can go to the next slide. One of those common policies that's likely to receive stricter scrutiny from the board is the way in which companies utilize confidentiality agreements with employees. Now, again, we need to look back at what the board has done before. And pre-2017, the board put into place a number of rules that restricted, for example, policies that required confidentiality from employees taking part in company investigations, also restricting the way that companies used confidentiality provisions of things like separation agreements. And the pre-Trump board justified its decisions to strike down these kinds of policies by arguing basically that workers shouldn't be required to keep as confidential things that affect the terms and conditions of their employment. Obviously, there were critics that said this runs against what has historically been done. Confidentiality provisions are used in things like separation agreements all the time. And so in 2019, during the Trump board, the board changed course and largely said that companies would be allowed to use these kinds of agreements. However, as I stated before, this is likely to be short-lived. The general counsel has largely indicated that these kinds of policies are going to be put on the chopping block, which is likely to affect the way that pretty much all companies, regardless of unionization status, utilize things like confidentiality agreements and various policies or contracts or agreements that it has with various members of its employment staff. If we can go to the next slide. Another thing that's likely to receive stricter scrutiny are companies' communication systems. Back in 2014, the board issued a decision called Purple Communications that I'm sure a lot of employers have heard about or had many discussions about. And that decision prohibited employers from restricting employees' use of the company's email systems that was being used on non-working time for non-work related issues. And in 2019, the Trump board reversed that decision and said that no, employers can lawfully restrict the communication system, the use of their communication systems for non-work purposes, so long as the policy is applied in a non-discriminatory way. This line of cases it's gone back and forth quite a bit, and it's likely to be the beach ball that just never drops. It keeps getting batted around from side to side. And sure, what is no surprise is that the new general counsel has identified that 2019 case as one that's ripe for reversal. And she's expressed not only an interest to return back to the Purple Communication Standard, but also to broaden its applicability by expanding it to communication systems such as Discord, Slack, GroupMe, or other communication systems that are used in a more modern workplace. Again, this is regardless of unionization status and will likely affect companies on a broader scale, or at least leave them liable to a charge brought before the National Labor Relations Board. Go to the next slide. So moving a little bit away from specific policies, the board's general counsel has also expressed interest in broadening some of the legal standards regarding who is allowed on employer property, when and in what capacity they are allowed to be present. And one of those includes specifically whether and when non-union affiliated employees, when those employees have a right to representation, which usually comes in the form of a coworker because you're not represented by a union, during certain meetings or interviews that could lead to disciplinary action. Now, as you can see here, the board is flip-flop and really goes back further than this, roughly over the last 40 years, on whether those non-union employees enjoy a right to have a coworker present during that kind of meeting that could lead to disciplinary action. So in 2000, the board said yes, even non-union employees have what are known as Weingarten rights, a right to have a representative present. And pretty quickly thereafter, in 2004, the board reversed itself and said, no, we're not extending Weingarten rights out to non-union employees. The new general counsel has at least expressed an interest in finding cases to potentially return back to the 2000 standard, where employees could request that a coworker be present, which would cause delays to various proceedings that the companies may try to get into with their employees and affect how those processes run. Dan?
Thank you, Garrett. Can we move on to the next slide, please? So the general counsel is also explicitly looking to toughen the remedies that are imposed on employers for violating the act. And this is obviously important because we all care about remedies, but it's particularly important because I think in a lot of cases, many employers viewed the risk when you go in front of the NLRB in like a discharge case or other types of cases as pretty minimal, right? You might have to pay back pay if you were found to unlawfully terminate an employee. You might get a cease and desist order, slap on the wrist. It was worth the risk. Well, Mr. Abruzzo is aware of that, and she has encouraged the regions to request a quote full panoply of remedies from the board in the cases they are bringing to ensure that victims of unlawful conduct are made whole for losses suffered as a result of unfair labor practice. And a memo she issued back in September listed a number of the remedies that regions should request. And one of those remedies is consequential damages, which the board recently agreed to explore in a case. And specifically, the board is considering whether consequential damages can be awarded as part of a make-whole remedy for an employee who's been unlawfully terminated. And these types of damages would be separate from the traditional loss of back pay and benefits. They could include healthcare expenses that were incurred due to the loss of health insurance that resulted from a termination. Compensation for credit card late fees that the employee incurred because after losing their job, the employee can no longer make their credit card payments. Damages for the loss of a home or a car, similar that the employee suffered as a result of an unlawful discharge that thereby prevented the employee from keeping up with payments. So this is a far-reaching change in the type of exposure that an employer could face from a charge alleging an unlawful discharge of an employee. And again, these remedies apply whether or not the employee is represented by a union. Other new remedies that Mr. Abruzzo wants to seek include front pay, liquidated damages. She's called for special forms of relief for undocumented workers. And also interesting in the non-union world, for unlawful conduct committed during an organizing drive, Mr. Abruzzo is urging the regions to seek expansive remedies like union access to employer property during the organizing drive, reimbursement by the employer for the cost that the union incurs in its organizing activity, paying the union for organizing your employees, NLRB access to the employer's property and records to monitor compliance with the NLRB's orders, and my favorite, training of employees, supervisors, and managers of employee rights under the Act. So part of a remedy for unlawful activity during an organizing drive would be to train your employees on their rights under the Act, essentially union campaigning. So again, non-union employers could find themselves facing far stiffer remedial orders for ULPs for unfair labor practices, including terms that could foster even more employee activism and generate more organizing activity. Next slide, please. The last area we're covering today on Abruzzo's agenda is employee status. Now, independent contractors are not covered by the NLRA. They have no Section 7 rights, no right to unionize. They're simply not covered. So the definition of employee status that the board uses is significant because it determines the scope of the coverage of the law. And there was a Trump era NLRB decision that lowered the bar for independent contractor status, that sort of made more workers excluded from the Act's coverage. Ms. Abruzzo named that decision as one of her targets for reversal. But more ominously for employers, she also appears interested in pushing the theory that a misclassification of an employee itself could be a violation of the NLRA. So an employer who mistakenly classifies an employee as an independent contractor, even totally in good faith, could find itself in violation of the law and facing remedies that make it easier for employees to organize. So non-union employers, particularly those that rely on a lot of contractors, should be aware of this issue as it develops, and we will be monitoring it. I see Dina is here. Do we need to wrap up at this moment, or should I skip to the last slide there?
Yeah, sure. Finish up, Dan.
Okay, so let's move on to the last slide. We're going to cover the PRO Act, which is legislation that's in Congress. All you need to know right now is that it's stalled. Follow our blog. We'll let you know if anything happens there. If we can move to the next slide, please. So the last area I want to cover, got that plug in there for the blog. Couple hot topics that I think will be of interest to employers here. These were decisions issued by the NLRB Advice Division, which gives guidance to regional offices on how to handle particular cases. So in Renewal by Anderson, a group of employees, non-union employees, were required to use a group chat app, GroupMe, to communicate about work assignments and operations. One employee used the app to message his coworkers about rising COVID rates in the area, expressing concern about the safety of coming to work. The employer didn't like that, told the employee to stop, and then remove the employee from the group chat. The employer told the employee he couldn't. The employee then said, "I'm not going to report to work because I don't think it's safe here, and I don't think it's safe that you're preventing me from discussing these dangers with my coworkers." The employer considered that a resignation. The NLRB said it was a constructive discharge, found that the messages on the GroupMe app were protected activity, and that the employer violated the employee's Section 7 rights by prohibiting him from discussing safety issues on the group chat app. So the takeaway here is discussions about COVID dangers and risks can qualify as protected concerted activity. And two, that the NLRB seems clearly aimed at making all channels of communication that an employer uses available to employees to discuss their working conditions. So if you see any of those things happening, pause and consider them rather than taking quick action because there could be NLRA exposure there. And I'll leave it there and hand it off to Dina. Thank you very much.
Well, the final CLE code for those looking for it is 49568. Again, the final code is 49568. That is the end of our substantive presentation. We do want to take questions for everybody who would like to ask them or who has asked them and would like some answers. So we'll give everybody a minute who we'll take just a minute break for those individuals who want to leave and go on with their day. Thank you, everyone, for joining us today. We hope you enjoyed our presentation. It is our pleasure to have this annual executive series presentation each year. And I'm going to ask the presenters to jump on right now, and we can certainly answer the questions. I got to put it in a different view. Okay, here we go. All right, so we had some questions in the first session that I want to circle back to. So I know Rob and Lisa, I was sending you those during the presentation. I'm going to go back to some of them, and then we're getting some new questions now in the chat, which is great. So in a 75% virtual shop where mostly everyone works remotely, are they required to mandate vaccines or weekly testing where the individuals don't have interaction with each other, and at whose cost? So I thought that was a really interesting question, because right now, before the federal mandate comes out, we're certainly not sure what's going to happen there. But right now, is there any mandate?
So, Dina, it was not clear exactly what type of mandate the person is talking about. If it is the federal contractor mandate, then there are situations in which remote workers do have to be vaccinated. For the OSHA 100+ rule, we have no idea yet what that's going to mean. And depending on state or local mandates that are out there, whether it's an Illinois statewide one, a city of Philadelphia, or others, then it all depends on the language of the particular order or the particular mandate, and they're all over the map. So the answer, unfortunately, is it depends on which mandate you're talking about, and we don't know the answer yet for OSHA.
So
Right,
Rob, not that you're a betting man, but do you have a sense about, given this administration, what OSHA is likely to do? Are they likely to say, if you have 100 or more employees, regardless of where your employees are, they need to be vaccinated or tested?
My bet is that they will not include 100% remote workers if they never come into the office. And the reason is it'll be a more defensible workplace safety rule. OSHA has never extended to the safety of home workplaces. So my guess would be against that.
Okay.
Great. And, you know, one thing I just want to chime in on, with many of our clients who have offices in different locations in different states, this has been a really big challenge for those who want to mandate vaccines. And what Rob said is true. You know, you really need to pull up the statute or executive order or whatever it is and look at that in particular. When the Biden order comes out and we have to look at that, will that ultimately supersede those orders? Again, we're going to need to look at it. So sorry to not give a concrete answer, but it's very hard. These times are challenging. Again, this is also going to be, I think we need to wait and see, but does the 100+ rule refer to a whole company, including all locations, if no one location has 100 employees?
Our best guess is that they'll count to 100 the same way they count to 100 every other federal law we've seen. Lisa mentioned that during the presentation, whether it's FMLA or EEO ones, which would be all employees, all locations.
Great. So this was an interesting one. So do the rules, and again, or which rules are we talking about? Not sure, but do the rules apply to board of directors and passive business owners, or are we only talking about employees?
I think Lisa responded to this privately. I've yet to see any of these requirements that would extend past employees. Some of them might reach independent contractors, but however, if those individuals are working on the covered workplace, so if you had passive investors or directors who are there on workplaces, I'm not sure under the federal contractor rule, but my guess would be no, they're not going to be covered.
Well, the other place that they may get covered, of course, is that some employers are putting policies in place that says if you are coming into the physical office, whether or not you're a visitor, a vendor, a third party, you need to be vaccinated. So it could be that if boards of directors are showing up for board meetings at a place where the employer or the third party has dictated that everybody needs to be vaccinated, that may be a backdoor way of having the board members who may not be passive or involved in a project, right? They could be covered in a different direction.
Correct.
That's correct. Can you speak to the challenges with taking the position that remote work is not a reasonable accommodation, since many of us have been working remotely for over a year? And I'd like to address this just for a minute. You know, the new EEOC, or the EEOC, has been issuing these technical guidance, and they've addressed this recently, and they address it sort of both ways, right? What they say is, can an employee use the fact that they've been remote for a year and a half as evidence that, now they can be remote? And the EEOC actually answers it sort of in both directions, right? They say, well, no, right? It's not a reasonable accommodation just because they've been remote during COVID, because everybody had to be remote for at least a period of time during COVID. But at the same time, the fact that the position was available and able to be worked remotely should be one of the factors that employers look at when determining whether or not the position can be worked remotely. So, they sort of answer out of both sides of their mouth on that one and say, what I would say, and this came out, I think, well in Alex's presentation, is the interactive process is going to be key, right? You really need to ensure that when you're looking at accommodation requests under the ADA, that you're engaging in that process. It's not a one size fit all. We don't want to see our clients saying, no remote work start, after, January 1. Everybody must be in the office, no exceptions, right? We have to make sure that we're looking at this on a case-by-case basis and based on the disability and the job and the issue and that sort of thing. This one is a contractor. If my company has a federal contract that only provides insurance services to the agency's contractors, and the contractors pay us directly, are we exempt because the government isn't paying us?
The answer is, I don't know. And
I was wondering that because
and
it wasn't answered.
And you're really going to have to wait for the agency that offers that contract. My best guess is that the insurance products are going to be treated analogous to other products because you're not supplying people. But that's really going to be a flow down from the agency that's giving the contract through the prime or to you to tell you whether that falls in the services category or product category. So I think it's going to be specific to the contract.
Okay, so here's a question that we sort of answered, but let's go back to it. You guys can still hear me, right? I'm not really on screen. I'm looking at the questions. If we accommodate a coworker by removing an essential job function like community visits with clients based on a medical or religious exemption, can we create a different job description and lower the salary range for doing everything except for the face-to-face interactions in the community? Our contract requires these one-on-one visits, and we will lose a substantial number of employees. It doesn't seem equitable to remove this and not lower salary.
So the answer is maybe. When you go back to ADA 101, you have to exhaust all of the other types of accommodations and consider them on ways to reduce risk. But after you go through everything else, if there's no other effective accommodation that provides a safe workplace, then transfer to a different position, or even a restructuring of a position is sort of last on the list before termination of things you need to consider as possibilities. And one of the last accommodation options, this was back to the 1990 guidance, is transfer to a lower position, or in this case, restructuring a position to remove what's otherwise an essential function and reducing the salary. You don't always have to keep the same salary.
But at the same time, I do want to note that the ADA does not require employers to create a new position or change the fundamentals of a position because a request has been made, right? So if this travel and interaction is the key purpose, the primary purpose, and an essential function of the job, you might look at other open positions as an alternative, but you should not be changing the fundamentals of the role itself simply because of an accommodation. So that's all part of the interactive process, but I did want to note that.
Thank
The
you.
reality, of course, is that with the shortage of workers, right, Lisa, employers may be forced to do that. Even though they're not legally required to do it, they may need help in this area and they're willing to restructure. But as Rob and you have both said, under those circumstances, if you're removing an essential function, which there was revenue associated with it, adjusting that compensation and leaving it up, then it's up to the employee whether or not they take it or not.
Can someone speak to the termination of clinical employees with tenure or employees with ongoing employment agreements based on that employee's refusal to take a mandatory or required vaccination?
Well, that's a two-part consideration. Number one, if there's a contract in place, right, you always have to consider the terms of the contract. And if you're even able to terminate, usually there's a notice provision, right, if there's a certain term of employment. So we have to be mindful of the actual terms. And then you have to be mindful of what the basis of the refusal to take the vaccine to get vaccinated is. And just as we've said for everyone else, contract or no contract, if the basis of the refusal is a disability or religious exemption request, you have to follow the process of reviewing the request, for disability, determining if it's qualified under the ADA and whether there's a reasonable accommodation. For religious, is it a sincerely held religious belief, and follow those processes before making any sort of decisions about termination.
So I could have an executive agreement that has very high standards for termination that would not be violated by just refusing a new requirement or the standards for tenure for a professor. It may well be a challenge to show that this new rule. It's all going to depend upon how those tenure terms have been interpreted in the past.
And the language of the for cause provision, are we now going to have to start drafting for cause provisions that has refusal to get vaccinated as a, one of those things like insubordination or violation of company policy? It may well be violation of company policy that you may be able to get it, again, depending on the language of for cause in an executive employment agreement.
Would DoD subcontractors need to submit to their contractor an exemption if they do not comply, or since they are not employees, can they be automatically relieved of their duties without any legal risk?
So this is the DoD subs to the prime.
Yeah.
The subs are all covered under the executive order to the prime. Who they have to provide the proof of vaccination to is a different question. That's the prime's obligation to be able to provide them to the agency on request. So those rules flow down. But however, if those subs are independent contractors, again, they're still subcontractors, and I think they're going to be covered.
So Rob, let me follow up with you and ask you are you getting this example from some of the clients that you're counseling, which is the prime or the sub, depending on which way it's going, as flowed down, is asking for proof of vaccination. And is it simply a representation by the prime to the sub to the prime? Yes, our people are vaccinated. Or can the prime require the sub to show all the vaccine cards that they've collected from their employees?
Actually, the FAQs are pretty clear that the obligation is to provide the proof of vaccination, which is a card, and I forget what the other requirement are, but there are specific rules for what constitutes proof that you have to be able to provide on request flowing up the chain.
And then I think the last question, although I will give an opportunity for others, this is for remote work. Is it foolhardy for an organization to proceed with remote work using non-legally binding guidelines as opposed to putting in place an official policy? And is the risk of litigation magnified due to decentralization, meaning we're going to rely on supervisors to administer the guidelines rather than sort of a centralized HR?
I think that that's a great question. The best practice would be to have a formal policy, to put it in front of employees, to have them execute it, and really also to have training on that policy so that employees are crystal clear with regard to what the expectations of their conduct and behavior is while they're working remotely. If you have looser guidelines, there's the potential that there's miscommunication with regard to what's allowed, with regard to what employees are able to do when they're working remotely. There's not, kind of one place to look for a uniform set of rules with regard to how the plan is administered, which might lead to, more discrimination claims and what have you. So I think it's a best practice to have a written policy and to have it, as detailed and comprehensive as possible. Otherwise you do run into some potential issues. With regard to administration, centralized administration of, approving remote work and calling balls and strikes in that regard, I think is always preferable. It's not always practical, but every time you've got different supervisors making different decisions, I think it creates a little bit more risk that there's a perception that the policy is being administered in a way that's not uniform across the organization. So if possible, I would say that it would be helpful for there to be some kind of centralized decision making on the basis of recommendations or input from supervisors if it's possible. But like I said, that may provide some practical issues, and those would need to be taken into account as well.
One question I'm not sure we answered back when we were talking about testing and things like that, the new regulations is whether temporary staff employed by a staffing agency are considered employees as part of the main employer. I just don't remember if we answered that or if we don't know yet as part of the new rules and regulations.
We partially answered that, Dina. For the government contractor rule, employees are going to be employees regardless of whether they're temp or full-time if they're working on the contract or working on a covered workplace. For the OSHA rule, I don't think we know the answer yet.
Okay.
Hey, Dina, I just wanted to circle back to one of your questions about accommodation and telework. One note I wanted to make to our guests is a really good resource is the EEOC technical assistance on with the Q&A, which was actually just updated on Monday, October 25th. And that particular question, which you answered about teleworking, is actually right on, as you mentioned, in those Q&A, particularly section D16, I believe. So if we can, I'd love for us to provide that link to our guests later, or I know I posted it in the Q&A, but I think it's really a great resource for our guests to have.
Maybe when, Chris, when we send out the materials, we can also send out to all of the registered guests the link to that Q&A, to the EEOC technical assistance guide. I think that's a great idea.
And
Sure,
for all
we can
of
do
our
that.
guests- Thanks, Chris. For all of our guests also, you're going to be getting information about, if you're not already registered for our blog, there's a simple way to do so. And we expect the EEOC will be coming out with some additional guidance. They've indicated when they put out the guidance on the religious accommodations that more guidance was going to be followed on the health issues related to accommodations for those who do not want to be vaccinated for whatever compromised reasons. So another resource that you can look forward to going forward as we continue the discussion, the dialogue. Today is probably just the beginning or the middle of where we are on this. We have a long way to go, and I think there's going to be a lot of case law and things like that that happens certainly over the next couple of months, if not years, dealing with the issues that we're talking about today.
Okay, a couple more questions. One of our participants wants to understand the cost aspect of testing. this participant and many others, right? If our employees have an exemption, does the employer need to pay for the testing?
So we covered this, I know, quickly, and I'll give you our two best answers right now. There is the question of the time to get tested. Then there's the question of the cost of the test itself. And until DOL gives specific guidance based on past guidance and memoranda, the time spent by a non-exempt worker taking the test, getting a required test as a condition of employment, is going to be compensable time. And that wouldn't be true for the non-exempt workers. There is a de minimis exception. So if all you're asking somebody to do is do a rapid test at home in less than 10 minutes, you may not have to pay for the time for the exempt worker. But if they have to go to the clinic or a minute clinic, they would. For the cost of the test, at this point, getting a COVID test is free. It's covered by federal insurance and various federal laws. But if there end up being co-pays or things down the road, we don't know. There is some good, in the prior OSHA rule for healthcare folks, they had to pay for the cost of the test. The EEOC suggests that if there's an exemption, you might have to pay for the cost, but they don't expressly say so. So we just don't know how that's going to play out.
Right. Of course, the home tests are not free. Those
And the home
you have
tests
to
are
go
not
buy
free.
at your local drugstore.
Yeah.
Can we require home healthcare workers to be vaccinated? I mean, I don't see why the answer to that would be anything other than yes, but does anybody have any other ideas on that one? No.
In general, you can require any employee to be vaccinated. The question is always, is there an exemption that they're qualified, in terms of disability or religious, that we need to consider under the law? But in general, across the board, you can require employees to be vaccinated.
And some home healthcare entities are being covered under the HHS rules that came out several months ago. Anyway, that's where many of them are required to.
And then this one's a doozy, so I was saving it for the end, although if anybody has other questions, please shoot them out. But so what suffices as a religious accommodation from vaccination? And I know we sort of ran through that end piece on religious accommodation quickly. And this is a doozy, but so what is a religious what suffices as a religious exemption from the vaccination? I mean, I just want to throw out there that we are dealing with clients who are getting all sorts of different types of religious accommodation requests. Some, on their face seem valid, some do not. But what is a religious an exemption from the vaccination?
Well, let's start with the classic example. There are two organized religions that oppose all healthcare treatment whatsoever, including Christian Scientists. And individuals who profess those faiths can show consistent pattern of never getting or approving any kind of medical treatment of any kind based on sincerely held religious beliefs. Those would be two examples that would clearly qualify. Whether what you do on the undue hardship side or alternatives is part two, but it would be a sincerely held religious belief. Beyond that, I am a skeptic on most of the other claims, but there are things that I have seen so far about small sects or of people or small groups of people of faith who profess to have similar rules about an all natural lifestyle or one that never involves medical treatment, that even if I haven't heard of it, that might be a sincerely held religious belief. But if you go down on the list of the issues in the slides of what are not religious beliefs, in most cases, these other boilerplate templates are going to fall. And on close inquiry of consistency or asking questions about what they've done or really listening about what their complaints are, they are all going to be political, social, medical, fear, other reasons that are not religious beliefs.
I do just want to add on that because we had a question on this. An employee is not required to provide documentation from a pastor or other religious leader to verify their religious belief. So while certainly you can and should ask questions to probe the nature of their request and whether the belief is sincerely held, under the law, you cannot require that they provide proof from someone who claims to be a religious leader to verify that they have a sincerely held religious belief.
But if they do provide one, that itself is not dispositive, because
That's also true.
we have seen, organizations that will give a pastor's letter to anybody who makes an inquiry to their website.
Right.
But Rob and Lisa, just to be clear about something, employers are not obligated to go to the next step of challenging or doing an inquiry into the sincerely held religious belief. Meaning, if an employer makes a decision that if an employee comes forward and says, I have a sincerely held religious belief, an employer can just accept that. There's not, we've given them guidance that allows them to inquire further, but it is not mandated under the law that an employer actually take those steps, correct?
Correct. And the safest position is just to grant everyone that anybody who comes on in and does it. But given the number of these objections that are being made, my advice is if you're overwhelmed, as many of our clients are with these requests, and just don't even know how to triage them, to accept it conditionally and say, we're going to accept it at this time and we're going to review it in 90 days and we may ask for more information later, and then move on to the next step of, can I accommodate it? What are the safety risks? What are the alternatives? You don't have to accept it forever if you condition it up front or if circumstances change. And that's what the EEOC said in Monday's guidance.
Has anyone seen accommodation requests from the testing requirement?
Actually, I have, Dina. It's a much smaller number, but have had at least a couple clients involving both students and employees where people were objecting to the tests themselves. And the usual response was that it was an invasive procedure, that even putting a swab up a nose is an invasive procedure, and that they were opposed to all invasive procedures. Now, under that definition, it would also be invasive if you've ever gone to the dentist and had something put in your mouth. So I don't think a whole lot of these are going to hold up to scrutiny, but you may get some small number. Most of the other objections I've seen to testing have been simply, it's not necessary because I'm immune from COVID.
Right. Okay, well, I think we've answered all of the questions that were asked of us. We have a couple of minutes left. Does anybody have any other questions, any of the participants? If not, I think that we are done. We want to again thank everybody for your interaction. I mean, it's always hard on these webinars to have the interaction with the audience, but we really did have excellent interaction today. So thank you to our participants, to our presenters, and of course to our marketing and events people for making this such a wonderful presentation today. And I think that's it. Thanks, everybody.